constitutional allegations including gross violation of the Constitution, abuse of office, and corruption, for which 12 days was structurally insufficient. As the Supreme Court affirmed in Sonko case, which we referred above, impeachment proceedings attract the protections of Article 50, and where a fair hearing is denied, the process collapses. On the issue of bias and predetermination, Learned Counsel submitted that both Speakers of Parliament, as presiding officers over the impeachment motion, were constitutionally required to maintain impartiality, but acted contrary. It was argued that they assumed the role of initiators and proponents of the impeachment, thereby transforming into advocates for the motion rather than neutral arbiters. In particular, Speaker Moses Wetangula of the National Assembly was said to have participated in public statements endorsing the impeachment before presiding over the proceedings. Counsel emphasized that the test for bias is objective, where a reasonable, fair-minded observer would conclude that there exists a real possibility of bias, and submitted that the Speaker's public statements and advocacy for impeachment satisfied this threshold. Where the presiding officer is biased, she argued, the proceedings are fundamentally unfair, and the failure of the speakers to rescue themselves irredeemably tainted the process. For the above reasons, Honorable Maina urged the court to grant the relief sought in her petition. Next is the 4th to 8th petitioners' cases. The 4th to 8th petitioners in the consolidated petitions, that is Honorable David Munyi, Kirinyaga County, and stated that they instituted the petition both in their personal capacities on behalf of their residents of their respective constituencies and in the wider public interest. The petitioners herein challenged the constitutionality, legality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachaguas, together with the subsequent nomination and approval process relating to Honorable Kindiki, relating to His Excellency Kindiki as Deputy President nominee. They contended that the public participation process conducted by the National Assembly on the 4th and 5th of meaningful participation as required under Articles 10 and 118 of the Constitution. The petitioners further asserted that Senate unlawfully conducted impeachment proceedings in plenary instead of through a special committee under Article 145(3)(b) of the Constitution, and that the rash timelines imposed under Standing Order 64(2) of the National Assembly standing orders were unconstitutional as they curtailed effective public participation and the hearing and the fair hearing rights. They also alleged that the Senate violated His Excellency Gachaguas' constitutional allegations. They also alleged that the Senate violated His Excellency Gachaguas' non-derogable rights under Article 25(c) and 50 of the Constitution by refusing to adjourn proceedings on the 17th of October 2024, despite his hospitalization and medical emergency, thereby denying him an adequate opportunity to be heard. In addition, the petitioners challenged the legality of the nomination and approval process of His Excellency Kindiki as Deputy President nominee, contending that the process contravened Sections 3 and 6 of the Public Appointments Parliamentary Approval Act, Chapter 7 of the Laws of Kenya, for want of adequate notice and public participation. The petitioners then sought the following prayers. A declaration that the appointment of Professor Kithure Kindiki, the second interested party herein, as Deputy President of the Republic of Kenya is invalid, null and void. B, a declaration that the National Assembly as a distinct organ is required to undertake its own distinct proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to the impeachment of a president or a deputy president. C, a declaration that the Senate as a distinct organ was required to undertake on its own distinct, proper, effective, and meaningful public participation as envisaged under Articles 10 and 118 of the Constitution in regard to a resolution from the National Assembly to impeach a president or a deputy president. D, a declaration that the public participation as scheduled by the first and the second respondent on 4th of October regarding the special motion was not a proper and effective and meaningful public participation as envisaged in Articles 10 and 18 of the Constitution. E, a declaration that the extended public participation scheduled by the first and second respondents on 5th October 2024 was in disregard of the court orders issued by the High Court sitting at Kerugoya in constitutional petition number E014 of 2024, Honorable Jane Jerry Maina versus the National Assembly and 4 others, and was not a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. F, a declaration that the impeachment process as against the first interested party was undertaken by the first and second respondents in view of the impugned, improper, ineffective, and meaningful public participation held on the 4th and 5th October was unconstitutional and therefore void. G, a declaration that the failure by the third and the fourth respondents to undertake any public participation at all in regard to the impeachment proceedings in the Senate as against the first interested party renders the whole Senate impeachment process unlawful and void. H, an order of certiorari to bring up into this honorable court and quash the decision and or the resolution by the first and the third respondents met on the 8th of October 2024 and 17th of October 2024, respectively, resolving to remove the first interested party as deputy president of Kenya by impeachment. I, a declaration that there exists no vacancy in the office of the deputy president, allowing the fifth respondent to nominate anyone to fill such vacancy, and that any such nomination is unlawful and void. J, any other order or orders that this court shall deem just and expedient in the circumstances. K, cost of the suit. Next is the 4th to 8th petitioners' submissions. In their submissions led by counsel, Mr. Evans Ogada, together with Mr. George Sakimpa, the 4th to 8th petitioners identify the following issues for court's determination. A, whether the impeachment process complied with Articles 10, 118, 145, and 150 of the Constitution, whether the public participation conducted by the National Assembly and the Senate met the constitutional threshold of being meaningful, adequate, effective, and lawful. C, whether Standing Order 64-2 of the National Assembly is unconstitutional for imposing rigid timelines that undermine constitutional safeguards. And D, whether Article 145 and applicable standing orders require that investigation into impeachment charges be conducted exclusively by a special committee of the Senate, not by the Senate sitting in plenary. They submitted that Article 10 binds all state organs, including Parliament, to the national values such as democracy, public participation, the rule of law, accountability, and good governance. That the impeachment process was conducted with severe haste and limited deliberation, undermining transparency, accountability, and public participation. They relied on the Supreme Court decision in Speak of the Senate versus AG and another report in 2013, where it was held that Parliament was not exempt from constitutional discipline. They submitted further that Article 118 required Parliament to conduct business openly and facilitate public participation, and that this was not a formality, but a substantive constitutional obligation. They contended that the National Assembly gave the public less than 48 hours to consider complex, voluminous impeachment charges, which is a manifestly inadequate time frame, that no
The Voto free tethered shooting tools. Anytime, anywhere. Effortlessly connect your iPad wirelessly. Seamless tethering.
Like Kirinyaga, designated venues were inaccessible. They further asserted that the Senate conducted no independent public participation at all, as it relied on the National Assembly's deficient exercise, which cannot cure the constitutional breach. And they relied on authorities in Law Society of Kenya versus National Assembly of Kenya, 3 others, reported in 2025 KLR, National Assembly and another versus Okoit and 55 others, Civil Appeal number E003 of 2023, consolidated with others. This is the decision of the Court of Appeal. They also relied on the decision of Doctors for Life and the decision in Legal Advice Center, and 2 others versus County Government of Mombasa. On the unconstitutionality of the National Assembly Standing Order 64-2, Learned Counsel argued that the provision imposes rigid and unreasonable timeline that make meaningful public participation impossible, and that while Article 124 empowered Parliament to make standing orders, such orders are subordinate to the Constitution and cannot defeat constitutional rights, and Article 2.4 voids any law inconsistent with the Constitution. The petitioners urge the court to declare Standing Order number 64-2 unconstitutional. As the matter in which the Senate proceedings were to be undertaken, Counsel submitted that Article 145.3 provided that the Senate must appoint a special committee to investigate impeachment charges, and that the use of the conjunctive "and" between sub-articles A and B makes the special committee process constitutionally inseparable from the investigative phase. That Articles 145, Sub-Article 4, Sub-Article 5, and Sub-Article 6 refer exclusively to the special committee, and that there is no mention of plenary investigation or under expresso inius est exclusio ulterius, that excluded all other modes of investigation. The petitioners submitted further that the special committee ensued suppression of investigations and adjudicative functions, preventing bias and predetermination, and the Senate's decision to bypass the special committee and proceed in plenary fused investigation, hearing, and the judgment into a single political process, violating the hierarchical and sequential structure of Article 145. Learned Counsel placed reliance on Martin Nyaga, Wambora, and 3 others was the Speaker of the Senate. This is the Court of Appeal decision, where the Court of Appeal held that the removal of a governor, which mirrors Article 145, is hierarchical and sequential in nature. Counsel argued that the Deputy President was denied a constitutionally prescribed procedural safeguard available to state officers facing removal, thereby violating Article 27 on equality and non-discrimination. They further submitted that Article 50, Sub-Article 1 guarantees the right to a fair hearing, which is expressly protected as non-derogable under Article 25C. Proceeding with impeachment proceedings while the Deputy President was hospitalized and rejecting a reasonable request for adjournment amounted to a gross violation of natural justice. Counsel emphasized that fairness was the unassailable foundation of any removal process. In support, they cited Gachaguas versus Speaker, National Assembly, and 3 others, High Court decision, where the High Court reaffirmed that the right to a fair hearing as non-derogable and that any violation renders the process null and void. Counsel concluded by submitting that the Constitution does not permit Parliament to sacrifice legality at the altar of expediency, and urged this court to reaffirm constitutional supremacy and protect the sovereignty of the people of Kenya. The petitioners prayed for declarations and that the impeachment process violated Article 10, 118, 145, and 150. A declaration that Standing Order 64-2 is unconstitutional, a declaration that the Senate unlawfully bypassed the special committee, and orders quashing the impeachment resolution. We'll now proceed to the 9th petitioner's case. Sheria Mtaani na Shedrack Wamboi, a public benefit organization, filed the petition dated 18th of October 2024, together with a supporting affidavit sworn by Dorcas Mwai, an advocate of the High Court of Kenya, and a director thereof. The petitioner stated that it is established to assist members of the public in assessing justice, protecting constitutional rights, and promoting the rule of law, constitutionalism, accountability, and good governance. The petition challenged the constitutional and the legal validity of the impeachment proceedings, leading to the removal of His Excellency Gachaguas from office as Deputy President, and further questioned the legality of the intended nomination and approval of His Excellency Kindiki as his replacement. It contended that the Senate proceedings conducted on the 17th of October 2024 violated His Excellency Gachaguas' constitutional rights under Article 25C, 47, 50, and 45, sub-Article 5 of the Constitution. That the Senate unreasonably declined to adjourn the impeachment proceedings, despite being informed that His Excellency Gachaguas had fallen ill and had been admitted at Karen Hospital, thereby denying him an opportunity to personally defend himself against impeachment charges. It was further alleged that the Senate acted in breach of the constitutional requirements of fair hearing, procedural fairness, and natural justice by proceeding with the impeachment in the absence of His Excellency Gachaguas, while allowing the proceedings to continue on the basis of strict constitutional timelines. It asserted that although the Constitution contemplated an expeditious impeachment process, the constitutional timelines could not override His Excellency Gachaguas' non-derogable right to a fair hearing and adequate opportunity to defend himself. Sheria Mtaani na Shedrack Wamboi further complained that the proceedings before Senate were rushed, insensitive, and conducted in a manner that prioritized speed over substantive justice and constitutional safeguards. Additionally, the 9th petitioner challenged the legality of the subsequent process initiated by His Excellency the President to nominate His Excellency Kindiki as Deputy President under Article 149 of the Constitution. It was contended that the nomination violated Articles 82, 88, and 137 of the Constitution because IIBC was allegedly not properly constituted and therefore incapable of lawful verifying the constitutional qualifications of any nominee to the office of the Deputy President. Sheria Mtaani na Shedrack Wamboi also argued that His Excellency Kindiki's nomination contravened Article 137 of the Constitution on the basis that he remained a serving Cabinet Secretary for Interior and National Administration at the time of his nomination. For these reasons, the organization sought the following prayers. A declaration be and is hereby issued that the rights and fundamental freedoms of the interested party herein to which his rights and fundamental freedoms under Articles 25, 50, 27, 47, 145 were grossly violated by the third respondent on the 17th of October 2024 for declining to grant him an adjournment on the Senate sitting deliberating on his removal from office by way of impeachment. B, a declaration does hereby issue that the decision by the third respondent to have the interested party removed from office by way of impeachment to the extent that it was done in gross violation of Articles 25, C, 50, 27, 47, and 145.5 of the Constitution was unconstitutional to the extent of its unconstitutionality and null and void ab initio. C, a declaration that any subsequent replacement of the interested party, if at all, to the office of the Deputy President of the Republic of Kenya was unconstitutional and therefore null and void ab initio. D, a judicial review order of certiorari does hereby issue to bring to its court to this court the decision of the third respondent as communicated via Gazette notice dated 17th of October 2024, communicating the removal from office of the Deputy President from the office by way of impeachment. E, a judicial review order of certiorari does hereby issue to bring to this court the decision of the President of the Republic of Kenya nominating His Excellency Kithure His Excellency Kindiki as the Deputy President of the Republic of Kenya for the purpose of quashing and the said appointment, and that the said appointment failed the qualification for the Deputy President as provided for under Article 137(2)(b) and 3 of the Constitution. F. Alternatively, this court be pleased to make a declaration that the appointment of the Deputy President by the President to fill in the vacancy arising from the removal of the interested party from office pursuant to Article 149 of the Constitution must be read together with Article 82 and 88 of the Constitution to give the IEBC its constitutional mandate to approve the name of the nominee as proposed under Article 149 of the Constitution. G. A declaration be made that the approval of Professor Kithure Kindiki or any other person as Deputy President of the Republic of Kenya is subject to Article 82 and 88 and 137 of the Constitution. Costs of the petition be provided, interest on one above at court rate till payment in full, and this court be pleased to make any further and other relief as it may deem fit in the circumstances. In respect of the 9th respondent submissions, led by Counsel Shadrach Wamoy, the 9th respondent identified 3 principal issues for court's determination. A. Whether the nomination of a Deputy President can be legally finalized or approved in the absence of a fully constituted commissioners of the IEBC under Articles 82 and 88 of the Constitution. B. Whether the Senate's refusal to grant His Excellency Gachaguas an adjournment due to documented illness during the impeachment proceedings constituted a breach of the rights to a fair hearing and natural justice under Articles 25C, 47 and 50 of the Constitution. And C. Whether the nomination of Honorable Kindiki while serving as a Cabinet Secretary is constitutionally infirm for violating eligibility criteria under Article 148 as read with Article 137. A learned counsel submitted that His Excellency Gachaguas fell suddenly ill on the afternoon of the 17th of October 2024 when he was scheduled to defend himself before the Senate, and that the Senate rushed the proceedings and unnecessarily and unreasonably declined to adjourn to allow him to recuperate. That the Senate proceeded with ex parte proceedings leading to his removal from office in his absence, which violated Articles 25C, 51, 47, and 145(5). The organization relied on the Supreme Court decision in Kidero and 4 others versus Waititu and 4 others, reported in 2014, which affirmed that fair hearing incorporates the audi alteram partem principle, and also referred to the Court of Appeal in Judicial Service Commission versus Mutava and another, reported in 2015, KLR, which held that rules of natural justice apply to all bodies exercising judicial, quasi-judicial, or 137, and that Article 137(1)(b) provides that a person is not eligible for nomination as President and by extension Deputy President if they hold any other state office, and that Article 260 defines state officer to include a Cabinet Secretary. It submitted that at the time of his nomination and parliamentary approval on 18th of October 2024, His Excellency Kindiki was serving as the Cabinet Secretary for Interior, and therefore he did not satisfy the constitutional eligibility criteria, rendering his nomination null and void ab initio. It was the organization's further submission that at the material time in October 2024, the IEBC was not fully constituted and it lacked the requisite number of commissioners as the previous commissioners had resigned or retired. Articles 82 and 88 establishes a constitutional architecture requiring a lawful and fully constituted IEBC to oversee electoral and nomination processes, and that the Supreme Court in IEBC versus AG Advisory Opinion number 4 of 2024, reported in 2025, held that a clear distinction must be drawn between administrative continuity by the Secretariat and the exercise of constitutional authority vested in the Commission as a collegial entity. It submitted that the exercise of constitutional functions reserved for the commission under Article 88, Sub-Article 4, cannot be lawfully discharged in the absence of a properly constituted commission with the requisite quorum. It was further submitted that in the absence of commissioners, IEBC was constitutionally incapable from undertaking its mandated electoral processes, and that the approval of a deputy president nominee, the second highest constitutional office, is no less a substantive constitutional responsibility than the limitation of boundaries, and the same principle applies with equal force. The organization urged this court to apply Article 10 on the national values and principle of governance that brings all state organs, Article 20, Sub-Article 3b in the Dubie Pro Libertate doctrine, that where in doubt, the court ought to adopt the interpretation that most favors enforcement of a right or freedom enunciated in Jacqueline Okuta and another versus AG, High Court reported in 2017, and that it further submitted that the unconstitutional exercise of a legislative mandate cannot be shielded from judicial scrutiny, as was held in Commission for Implementation of Constitution versus National Assembly of Kenya and two others, 2013, KLR reported. In the end, the petitioner prayed that the petition be accordingly allowed. I now proceed to the 10th to 41st petitioner's case. That's yours. That's yours. Proceed.
Let me take the 10th to 41st petitioner's case. The 10th to 41st petitioners are a group of Kenyan citizens and one registered association, primarily from Central Kenya region. They filed the petition dated the 17th of October 2024. That was amended on the 18th of June 2025 and re-amended on the 16th of December 2025. They challenged the constitutional validity of the impeachment process and subsequent removal of H.E. Gachaguas as Deputy President of Kenya, stating that the National Assembly and the Senate failed to comply with Article 152 of the Constitution, which requires them to modify the presidential impeachment procedure under Articles 144 and 145 for the Deputy President. They said that instead they applied the same rules under Standing Orders 64 and 65 for the National Assembly and Standing Orders 78 and 79 for the Senate without necessary modifications, ignoring that the Deputy President does not have the same powers, prestige, or legal immunities as the President. The entire impeachment process invalid, null and void ab initio, and violated the right to a fair hearing under Articles 25, 27, and 50. It was their further position that the impeachment was not a genuine parliamentary process, but was engineered, sponsored, and bulldozed by political and financial inducements to capture Parliament, turning it into a tool to remove the DP and settle political scores, thereby subverting the sovereign will of the people who elected the Deputy President in the August 2022 general election. They asserted that the President and the Deputy President were elected on a joint ticket and that the impeachment violated the rights of the petitioners and other voters from the Central Kenya region who voted for that joint mandate. The petitioners also highlighted and incorporated arguments from Nairobi High Court Constitutional Petition 356 of 2024. In that matter, it was alleged that both H.E. President Ruto and H.E. Gachaguas had violated their oaths of office and the Constitution through various actions. Specifically, it was claimed that the president accepted foreign gifts valued at approximately Kenya shillings 240 million in the form of paid-for jet hire and fuel costs for a state visit to the United States, thereby exceeding the legal threshold permitted for such gifts. It was further alleged that the president entered into a secretive treaty with the United States to designate Kenya as a non-NATO ally without tabling the agreement before the National Assembly and Senate as required by constitutional oversight. Additional claims included intimidation and threats directed political defections to artificially control the majority party coalition. The petitioners accused the president of using state violence to criminalize and suppress the Gen Z, otherwise read the Generation X good governance protests, as well as the July 2023 protests against oppressive taxation and the high cost of living, and that he distributed state appointments along acute ethnic lines. Additionally, H.E. Gachaguas was faulted for publicly dividing Kenyan citizens into shareholders and non-shareholders in quotes based on political alignments, whereas H.E. President Ruto is accused of spending hundreds of millions of public funds to conduct avoidable by-elections caused by appointing sitting MPs and senators to the cabinet. The petitioners further argued that the Kenya Kwanza coalition agreement binds H.E. President Ruto to nominate a replacement deputy president from the Gikuyu, Embu, or Meru communities, which is the same region as the impeached deputy president. They sought a declaration that the president's power to nominate a new deputy president was subject to certification by the IEBC, that the nominee meets qualifications under Articles 99 and 137, stating that the 14-day and 60-day timelines in Article 149 were meant to ensure public participation across all 90 constituencies. Consequently, the petitioners asked the court to declare the nomination and approval of H.E. Kindiki as the new deputy president as unlawful, null, and void. The petitioners thus sought the following reliefs from this court. 1, a declaration be issued to declare that the first petitioner was impeached by the National Assembly and removed by the Senate under a procedure that violated Articles 27, 50, and 150 sub-Article 2 of the Constitution. 2, a declaration be issued to declare that the first and second respondents have violated the rights of the petitioners and other voters and residents of Central Kenya region by failing to govern together in accordance with their joint mandate secured during the presidential election held on the 9th of August 2022. 3, a declaration be issued to declare that the first petitioner was impeached by the Parliament under the respective standing orders of the National Assembly and the Senate that offends Article 150 sub-Article 2 of the Constitution. 4, a declaration be issued to declare that the impeachment of the first petitioner was null and void ab initio on account of the violation of Articles 25, 27, and 50 of the Constitution, read together with Articles 144, 145, and 150 of the Constitution. 5, a declaration be issued to declare that the second and third to 14th respondents have conspired and schemed to remove the second respondent from office through impeachment in violation of Articles 1, 27, and 38 of the Constitution. 6, a declaration be issued to declare that the second respondent violated Articles 110, 118, and 150 of the Constitution, and passing a resolution on 8 October 2024 to remove the second respondent from office. 7, an order of certiorari be issued to quash the resolution of the second respondent passed on 8 October 2024 to approve the motion of impeachment of the first petitioner tabled on 1 October 2024 by the 9th respondent. 8, a declaration be issued to declare that the 6th respondent's power under Article 149 of the Constitution to nominate a person to occupy the office of the Deputy President is subject to certification by the Independent Electoral and Boundaries Commission under Articles 99 and 137 of the Constitution. 9, a declaration be issued to declare that the 14 days period prescribed under Article 149 for the President to nominate a person to occupy the office of Deputy President is to ensure compliance with Articles 10, 38, 99, and 137 of the Constitution. 10, a declaration be issued to declare that the 60 days period prescribed under Article 149(1) of the Constitution for the National Assembly to vote on the President's nomination to fill the vacancy in the office of the Deputy President is to ensure compliance with the requirement of public participation in all the 290 constituencies in accordance with Article 1, 10, 27, 38, 118, and 136 of the Constitution. 11, that by dint of Articles 1, 10, 27, and 38 of the Constitution, the first respondent is bound by the Kenya Kwanza Coalition Agreement dated the 5th of April 2022 to nominate a qualified person from either of the Gikuyu, Embu, and Meru communities to fill the vacancy in the office of the Deputy President occasioned by the impeachment of the second respondent. 12, a declaration be issued to declare that the 6th respondent's nomination and of approval, therefore, by the National Assembly of H.E. Honorable Kithure Kindiki, the second interested party herein, as Deputy President is unlawful, null and void ab initio. 13, the Honorable Court be pleased to issue an order of certiorari to quash the nomination by the National Assembly of Honorable Kithure Kindiki as a Deputy President via Gazette notice published in a special issue of the Kenya Gazette dated 18th October 2024. And 14, a declaration be issued to declare that by dint of Articles 1, 10, 27, 38, 91, and 132 of the Constitution, the citizens of Kenya from the Gikuyu, Embu, and Meru communities have a right secured by the results of the presidential election held on 9th August 2022 to have one of them to occupy the office of the Deputy President during the tenure of the first respondent as the President of Kenya. 15, a declaration be issued to declare that Standing Orders number 64 and 65 of the National Assembly Standing Orders violates Article 152 of the Constitution. 16, an order of certiorari be issued to quash Standing Orders 64 and 65 of the National Assembly Standing Orders to the extent that they apply to the Deputy President. 17, a declaration be issued to declare the Standing Orders number 78 and 79 of the Senate adopted on the 16th of June 2024 violates Article 152 of the Constitution. 18, an order of certiorari be issued to quash Standing Orders number 78 and 79 of the Senate as adopted on 16th June 2024 to the extent that they apply to the Deputy President. 19, an order of mandamus be issued to compel the National Assembly and the Senate, that is the second and fourth respondents herein, to promulgate a procedure for removal of the Deputy President by impeachment envisaged by Article 152 of the Constitution. 20, that a declaration be issued to declare that the first petitioner was impeached through a procedure that amounted to political persecution and vendetta prescribed by Articles 1, 3, 38, and 50 of the Constitution. 21, that a declaration be issued to declare that the sixth respondent engineered, sponsored, and bulldozed the impeachment of the first petitioners in a manner that amounts to abuse of power in violation of Articles 1, 3, 38, 50, and 131(2) of the Constitution. 22, costs of the petition be borne by the first and fifth respondents. The 10th and 41st petitioners' submissions. In these submissions, the petitioners reiterated that the impeachment proceedings did not stem from legitimate constitutional violations. Instead, they arose directly from a severe political fallout and a politics of betrayal, in quotes, between HE President Ruto and HE Gachaguas. That the impeachment motion was originally assigned to Sirisia MP, Honorable John Waluke, but however, due to his tainted image from a high-profile corruption case, Honorable Mutuse was brought in as a substitute mover to table the motion on the 1st of October 2024. The petitioners listed the following issues for the court's determination. A, whether the impeachment of H.E. Gachaguas was a political witch hunt or a genuine procedure. B, whether H.E. Gachaguas was impeached by the National Assembly and the Senate under a procedure that violated Articles 27, 50, and 152 of the Constitution. C, whether H.E. Gachaguas was lawfully found guilty of Ground 1 of the Articles of Impeachment. D, whether the Standing Orders number 64 and 65 of the National Assembly and Standing Orders number 78 and 79 of the Senate, under which H.E. Gachaguas was impeached, violate Article 152 of the Constitution. E, whether the Senate's failure to establish a special committee under Article 145(6) of the Constitution rendered the removal of H.E. Gachaguas null and void ab initio. Issue F, whether H.E. Gachaguas was subjected to a lawful and fair trial by the Senate. G, whether the first to 11th respondents conspired or schemed to that the impeachment was completely manufactured by a political fallout rather than the genuine existence of any lawful grounds under Article 151(b) of the Constitution. That it was fundamentally unconstitutional for the executive and parliament to use the sacred device of impeachment as an administrative tool to resolve purely political disputes and vendetta. They submitted that the impeachment proceedings inside both the National Assembly and the Senate were weaponized and conducted in absolute violation of substantive and procedural provisions guaranteed under the Constitution, as well as the standing orders of both chambers. They specifically maintained that the current rules governing the process, that is, Standing Orders 64 and 65 of the National Assembly and Standing Orders 78 and 79 of the Senate, violate Article 150 sub-Article 2 of the Constitution and must be quashed. The petitioners equally submitted that H.E. President Ruto's power to nominate a replacement under Article 149 was strictly subject to certification by IEBC under Articles 99 and 137, and because the 14-day and 16-day constitutional windows under Article 149 are designed to guarantee rigorous public participation across all 290 constituencies, the rushed nomination and approval of H.E. Kindiki was unlawful. It was null and void ab initio. That rushing this process directly violated the political rights of the petitioners under Article 38. A fortiori, the petitioners argued that this court has an obligation to step in and quash the impeachment to halt an ongoing executive scheme to re-establish an imperial presidency in Kenya and they want that Parliament has become subservient and sycophantic to the executive. Party parliaments of the late 1980s, which present an existential threat, to Kenya's constitutional democracy. They recited the prayers that sought to declare the impeachment null, void, and an act of political persecution that violated Articles 25, 27, 50, and 150, 78, and 79 to the extent that they apply to the removal of a deputy president and orders to compel both chambers of parliament to promulgate a legally compliant, constitutionally envisaged procedure for removing a deputy president under Article 150, Sub-Article 2. The petitioners relied on various local authorities, including the Sonko case earlier mentioned, as well as Jirongo versus Soy Developers Limited. They also relied on foreign authorities, including Kriegler versus the Law Society of Alberta, Republic R versus Budry, R versus Campbell, R versus Reagan, all of which citations you will find in the judgment, all from the Supreme Court of Canada. Further reliance was placed on books, articles, speeches, and reports, as well as interview statement by Senator Edwin Sifuna on the Senate floor as per the Hansard of 9th October 2024, and an interview statement by H.E. Gachagua on Inoro TV. In the end, the petitioners prayed that their petition be allowed as prayed. Moving on to the 43rd petitioner's case, Mr. Morara Omoke filed a petition dated 9th October 2024 before the High Court of Kenya at Eldoret, together with a supporting affidavit sworn on the same date in his capacity as a Kenyan citizen and patriot, acting in defense of constitutionalism, the rule of law, and democratic governance. The petition challenged the constitutionality and legality of the impeachment proceedings commenced against H.E. Gachagua by the National Assembly and Senate. He contended that the impeachment process was politically motivated, defective, unconstitutional, and undertaken in violation of the sovereign will of the people expressed during the 2022 general election. His case centered on the alleged violations of Article 1, 10, 38, 47, 48, 50, 73, 75, 94, 118, 145, and 150 of the Constitution, that the impeachment motion tabled by the Honorable Motuse had not been preceded by adequate public participation, and that the MPs who appended their signatures in support of the motion failed to consult their constituents before supporting the impeachment process. He further alleged that the process of collecting signatures in support of the impeachment motion was tainted by bribery, undue influence, intimidation, and forgery of signatures belonging to some MPs. He contended that the subsequent public participation exercise conducted on 4th and 5th October 2024 was merely cosmetic and incapable of constituting meaningful public participation because it was hurried, poorly coordinated, inadequately publicized, and conducted through only one center per county and constituency. He also complained that the public participation forms contained only the allegations against H.E. Gachagua and omitted his responses, thereby condemning him unheard and violating the principles of fairness and natural judgment. Motion was politically motivated and arose from internal disputes within the UDA party, yet the parties involved had failed to exhaust internal party dispute resolution mechanisms under the party constitution before initiating impeachment proceedings. He also argued that there existed no comprehensive statutory framework governing impeachment proceedings and the collection of signatures for impeachment motions, thereby rendering the process legally deficient and constitutionally uncertain. Mr. Omoke then sought the following orders. A declaration that the impeachment motion moved by the third respondent does not meet the threshold set out in Article 145 as read with Article 150 of the Constitution. B, a declaration that the impeachment of Geoffrey Rigathi Gachagua was unconstitutional. C, a declaration that the Speaker and Deputy Speaker of the National Assembly were biased and ought to have disqualified themselves from the impeachment process. D, a declaration that the impeachment motion violated the interested parties' rights under Article 32, 33, 38, 47, 48.
My work is easy because I use ClickUp. Here's how I keep track of all my tasks.
The impeachment motion against the interested party was tabled in a manner that violates Article 110, 94, and 118 of the Constitution, as no public participation was conducted by Honorable Mutuse Ekomas Mwengi and by the members who appended their signatures prior to moving the impeachment motion in the National Assembly. F, a declaration that the impeachment motion, which was a result of a dispute in the United Democratic Alliance Party, was tabled before the National Assembly without exhaustion of internal remedies, contrary to the exhaustion doctrine and Article 159 of the Constitution of Kenya. G, a declaration that in the absence of an enabling legislation operationalizing the provisions of Article 150 of the Constitution of Kenya, there is no legislative and administrative framework within which the impeachment of the DP was anchored, and H, that each party bears its own costs. In his submissions, Mr. Omoke focused on two main issues, namely, whether the impeachment of H.E. Gachagua was unconstitutional and whether the lack of legislation to operationalize Article 150 of the Constitution vitiates the impeachment. He wholly adopted H.E. Gachagua's submissions dated 7th October 2025, submitting that the constitutionality of the impeachment transcends him and must be evaluated with a view to advancing constitutionalism and the rule of law. He maintained that public participation was inadequate and a sham, as the mover of the motion and the 291 MPs who appended their signatures in support of the impeachment motion did not conduct any public participation in their constituencies before signing, contrary to Articles 1, 10, 94, and 118 of the Constitution. That public participation was an afterthought, and when questions arose on 1st October 2024 about whether public participation should be conducted, the Speaker directed that it be held on 4th October 2024. The advertisement appeared on 2nd October 2024, which Mr. Omoke submitted was not a genuine intention to conduct any real public participation from the outset, that the public participation form provided by the National Assembly contained only the allegations against H.E. Gachagua and conveniently left out his response, denying the public the ability to effectively weigh the grossness of the alleged violations. He submitted that public hearings occurred for only 9 hours, from 8 a.m. to 5 p.m., on a normal workday, which was a Friday, meaning most Kenyans could not attend. That venues were changed on the eve of the exercise. For example, in Embu, it changed from IFAD Hall to Talent Academy, and in Nairobi, it changed from KICC to Bomas of Kenya. He submitted that in Kiambu constituency, only about 2,000 people attended in a county with over 1 million registered voters, that there was no proper coordination, and he described the situation as utter pandemonium akin to the Tower of Babel. He contended that in some areas, especially in Mount Kenya, public participation forms were faulty. There were incidents of pre-filled forms, and a vehicle ferrying pre-filled forms was torched in Nyeri County. That the National Assembly extended the exercise to the following day on the 5th of October 2024, but no proper notification was made and MPs kept away from the exercise. He added that in some constituencies like West Mugirango, the MP never opened the constituency office, and that the one center per county and one center per constituency is too deficient, as public participation should have been conducted at least at each polling station or at minimum each ward. Mr. Omoke submitted that the National Assembly neither processed nor considered the feedback collected, and the entire exercise was a mere sham to hoodwink innocent Kenyans. He accused Deputy Speaker Gladys Bose-Sholei of being biased in that on 23rd September 2024, while speaking at a function in Uasin Gishu County, she swore to spearhead the impeachment motion and put the Deputy President on notice, stating in quotes, "Mimi mwenyewe nitakupeleka nyumbani." In brackets, "I will personally take you home." That she also hinted at some of the grounds of impeachment before the motion was even tabled. He further argued that Speaker Moses Masika Wetangula on 29 September 2024, while attending a church function at Wamonyo Catholic Church in Machakos County, publicly took a stand on the impeachment motion before it was tabled. Using the biblical description in Mark 9:38-50, he stated that H.E. Gachagua, being a part of the body that leads to sin, should be cut off. These utterances he submitted violated Articles 47, 50, and 150 of the Constitution, and that neither the Speaker nor the Deputy Speaker should have presided over the impeachment motion. Mr. Omoke submitted that the Constitution sets a high threshold for impeachment as a measure is a grossness of alleged violations, and that grudges and squabbles cannot be the basis for removal. He contended that extraneous grounds were introduced on the floor on 8 October 2024, as it was alleged that H.E. Gachagua had referred to Honorable Florence Jematea Sergon, the countrywoman rep of Baringo, as that Honorable Karoli Omondi, MP Suba North, referred to conversations he had with H.E. Gachagua without providing any proof. Honorable Patrick Makau, MP Mavoko, also made references to conversations without providing any proof. On the vote that 281 MPs supported the motion, 44 opposed, and there was one absentee, Mr. Omoke submitted that MPs abdicated their obligation to weigh the grounds against the intermediate standard of proof set by the Supreme Court in Odinga and 5 others versus IEBC and 3 others. That the impeachment overturned the decision of 7,176,141 Kenyans who voted for the joint ticket on 9th August 2022, a decision upheld by the Supreme Court, and that the motion was an egregious overthrow of the decision of the majority with that of a few. It was Mr. Omoke's further submission that no statutory legislation exists on the process of impeachment of the President and Deputy President from start to completion, as no legal framework exists on the collection of signatures in support of an impeachment motion. Therefore, there is no framework upon which the impeachment of the Deputy President was anchored. He submitted that in D and others, that is the Attorney General, this court was persuaded by Mr. Omoke, who was a petitioner therein, that the lack of legislation on signature collection and verification and on the conduct of referenda initiated the BVI process. He submitted that the same principle applies here, and that legislation is so central to the fairness of the process that the court ought to, at minimum, issue a structural edict requiring enactment of this legislation. He submitted that areas requiring legislation include initiation of the impeachment process, how Parliament is to process impeachment, particularly public participation, and the actual impeachment trial, the replacement of an impeached deputy president, provision for judicial intervention before an impeached president or deputy president is replaced, including grant of conservatory orders to preserve the rights of the impeached official, and expeditious hearing of petitions arising from an impeachment. Mr. Omoke saw no reason why the court could not have maintained the conservatory orders in favor of H.E. Gachagua and had the petitions within a week or two. That the discharge of the orders, followed by an immediate declaration of a public holiday for the swearing in of a new deputy president, left a mind-boggling question on the efficacy of Article 50 of the Constitution. For these reasons, Mr. Omoke prayed for a declaration that the impeachment of H.E. Gachagua was unconstitutional, and that a declaration that the absence of legislation operationalizing Article 150 of the Constitution rendered the impeachment process of the Deputy President flawed. We look at the 44th to 48th petitioner's case. Abuli Namenya, Kennedy Kareithi Gachege, Dennis Okumu, Simon Mushangi, and Peter Maina Kanene jointly filed the petition dated 30th September 2024 before the High Court of Kenya at Nairobi. They describe themselves as Kenyan citizens committed to constitutionalism, the rule of law, and defense of the Constitution, and that they also instituted the petition in the public interest to challenge the proposed impeachment of H.E. Gachagua as Deputy Republic of Kenya. As per their petition and the supporting affidavit sworn by Abuli Namenya, the petitioners challenged the constitutionality of the impeachment process on the basis that Parliament had failed to establish a proper legal and procedural framework governing public participation in impeachment processes under Article 118 and 124 of the Constitution. The petitioners contended that neither the National Assembly standing orders nor the Senate standing orders provided mechanisms, procedures, threshold timelines, verification methods, venues, or modalities for meaningful public participation in impeachment proceedings, thereby rendering contemplated impeachment process unconstitutional. They further argued that public participation was a mandatory constitutional prerequisite which ought to precede any impeachment process, and asserted that the 7-day timelines prescribed under Standing Orders 64 and 73 for disposal of impeachment proceedings were inadequate and unconstitutional, as they public participation and violated the rights to fair administrative action and fair hearing under Articles 47 and 50 of the Constitution. The petitioners additionally alleged that the impeachment process was politically motivated and tainted by bias and lack of impartiality on the part of parliamentary leadership, citing public pronouncements by parliamentary leaders in support of the impeachment motion. They advanced a historical argument concerning the office of the Vice President and Deputy President in Kenya, contending that successive deputy presidents had historically been subjected to political hostility, dismissals, and frustration, which informed the constitutional design of 2010, requiring the president and deputy president to be elected jointly. The petitioners then sought the following prayers: a declaration that the impeachment process of a deputy president is a sui generis in nature, and that public participation forms a fundamental background that plays a significant role in attaining the right to a fair trial enshrined under Article 50 of the Constitution. B, a declaration that public participation is the only avenue or means through which the people can exercise their sovereignty contemplated under Article 1 of the Constitution in determining whether an office created under the Constitution ought to be abolished, or whether accountability mechanisms created under this Constitution ought to be put in motion or otherwise, and that the lack of elaborate procedure or certainty as to when the same should commence or conducted will ordinarily amount to usurpation of the people's power and subsequently amount to a violation of the Constitution. C, a declaration that the Article 118, Sub-Article 2, that clearly provides for mandatory public participation, and Article 124, creating the requisite parliamentary standing orders, neither the National Assembly nor the Senate had enacted an Act of Parliament providing for the procedure on how the impeachment of either the President or Deputy President is to be undertaken, nor has the National Assembly Standing Order 64 or 65 or the Senate Standing Order number 74 provided for the procedure element of public participation relating to the impeachment of a deputy president. D, a declaration that the National Assembly Standing Order 64 and 65 or the Senate Standing Order number 74 are unconstitutional, as they were never subjected to the mandatory public participation during their enactment. E, a declaration that the standing orders must with certainty and clarity provide that the public participation contemplated under Article 118 should be a conditional precedent that must precede all other processes relating, connected, or incidental to the impeachment of the Deputy President. F, a declaration that Article 27 requires that all Kenyans must be subjected to the principle of equality and equal protection of the law, while Article 47 requires that a person must be subjected to an administrative process that is procedurally fair, expedited, reasonable, and lawful, irrespective of one's status in society, and that the respondents herein have violated the same by commencing an impeachment process that is constitutionally tainted with illegalities. G, a declaration that public participation in an impeachment process is a fundamental infrastructure that facilitates the enjoyment of Article 50 and that the absence of the same will amount to the respondent's hearing, violating, denying, threatening, or infringing the interested party's right to a fair trial during his impeachment. H, a declaration that time is an important resource under the Constitution, and that the 7 days period for impeachment provided for under Standing Order 64-2B of the National Assembly Standing Orders and the Senate Standing Order 73-1 amounts to conducting a sham trial in, and the same will amount to a violation of Article 50. I, a declaration that Standing Order 64-2B of the National Assembly Standing Orders and the Senate Standing Order number 73-1 does not provide for the sufficient and adequate time for carrying out a qualitative, quantitative, meritorious, accurate, and secure public participation, the hearing and determination of the impeachment trial before Parliament that will result into a fair, just, impartial, and judicious determination of the impeachment trial as contemplated under Article 47 and 50 of the Constitution. J, a declaration that for purposes of authenticating and verifying the results of the participants taking part in the public participation, confirming all the requisite legal thresholds like that of citizenship, the total number of participants, public participation ought to be undertaken by an impartial state organ separate from Parliament. Looking at the 44th to 48th petitioners' submissions, led by Learned Counsel Mr. Njiro Ndegwa, the petitioners focused on the constitutional architecture governing impeachment of a deputy president, submitting that the process was fundamentally flawed because impeachment is a measure of last resort, not a primary accountability tool, and that the Senate failed to apply the mandatory modification rule under Article 152, which requires that Articles 144 and 145 be applied in quote with necessary modifications to the deputy president. Mr. Ndegwa submitted that the proceedings violated fair hearing rights under Article 50, including the refusal to adjourn when the deputy president fell ill, that the process was infected with bias, irrelevant considerations, and procedural violations of the Standing Order 75, 78, and 80, and that the cumulative defects render the entire impeachment null and void. The petitioners adopted and relied on H.E. Gachaguas' submissions and the Wambora principles on quasi-judicial impeachment proceedings and identified the following issues for determination: whether the impeachment of the deputy president met the constitutional threshold of a measure of last resort in light of the availability of alternative constitutional and statutory mechanisms, whether the constitutional framework governing the impeachment of a deputy president under Article 150, Sub-Article 2 was properly invoked, applied, and distinguished from the regime governing the impeachment of a president under Article 145, whether the Senate complied with the mandatory requirement to apply Articles 144 and 145 with necessary modifications as contemplated under Article 152 and Standing Order 79, whether the failure to apply the modification rule undermined the constitutional principles of sovereignty of the people, national values, and political rights, including the legitimate expectation of tenure. whether the impeachment process satisfies the constitutional and jurisprudential standards applicable to quasi-judicial proceedings as articulated in the Wambora decisions, whether the Senate's failure to comply with constitutional requirements renders the impeachment process null and void, whether the impeachment process violated the Deputy President's right to equality and equal protection of the law under Article 27, whether Parliament, in conducting the impeachment proceedings, acted as an impartial and unbiased quasi-judicial body as required by law, whether the debates and proceedings in both the Senate and the National Assembly were confined to the substantiation of the charges or were contaminated by irrelevant, extraneous, and prejudicial considerations, whether the refusal to grant an adjournment upon the Deputy President falling ill violated his right to a fair hearing under Article 50, including the right to be present and to be adequately present, to adequately present his defense, whether the Senate misapplied Standing Order 78 by proceeding under a plenary hearing without affording procedural safeguards and by improperly treating the proceedings as time-bound, whether the impeachment proceedings violated the Deputy President's right to adequate time and facilities to prepare a defense under Article 50, Subarticle 2A, and the right to be heard under Standing Order 80. Whether the Senate acted in violation of its own standing orders, including Standing Orders 75, 78, and 80, and the legal effect of such violations, whether sufficient time existed within the constitutional and procedural framework to accommodate adjournment and ensure a fair hearing, and whether failure to utilize such time rendered the process unconstitutional, whether the continuation of proceedings in light of the Deputy President's illness violated his fundamental rights to life, dignity, health, and access to justice under Articles 26, 28, 48, and the state obligations under Articles 10, 19, 20, and 21. And finally, what reliefs are available where a constitutional process is found to be procedurally and substantively defective. Learned Counsel submitted that impeachment is not intended to be a primary or convenient mechanism for addressing alleged misconduct, but rather an extraordinary remedy reserved for the clearest and most compelling cases where no other lawful avenue exists. They argued that the Constitution establishes a graduated hierarchy of accountability, beginning with civil liability, criminal prosecution, and administrative action, and only thereafter impeachment. It was emphasized that Article 143 expressly removes immunity from civil and criminal proceedings for the Deputy President, unlike the President. According to Mr. Ndegwa, this signals that allegations against a Deputy President should, in the first instance, be addressed through ordinary legal processes. Parliament, however, bypassed these mechanisms and resorted to impeachment as a first recourse, which Counsel contended offends the principles of proportionality, rationality, and legality. They further submitted that no evidence exists that Parliament considered whether the allegations could have been addressed through criminal investigation or civil proceedings before invoking impeachment. Counsel also drew attention to Article 152, which provides that Articles 144 and 145 apply to the Deputy President with the necessary modification. Counsel argued that this phrase is not ornamental, but a deliberate constitutional command requiring contextual adaptation of the presidential impeachment framework to the distinct office of the Deputy President. In their view, the requirement imposes an active obligation on the Senate to interrogate, adjust, and tailor the procedure rather than merely transplant it without reflection. Standing Order 79, they submitted, operationalizes this obligation by requiring the Senate to consciously and expressly apply the modification principle. Mr. Ndegwa submitted that nowhere in the Senate Hansard is the House on the necessity, the scope or content of the required modifications as the Senate proceeded as though Article 145 applied mutatis mutandis and in toto without any modification. He stated that this failure is not merely procedural but a substantive and jurisdictional issue which renders the entire process unconstitutionally defective ab initio. The petitioner submitted that this modification requirement ensures that impeachment is not invoked where alternative legal mechanisms such as the courts, EACC, or DCI are adequate. It was their case that the failure to modify denied the Deputy President the procedural safeguards that would have arisen from a properly tailored process, including consideration of alternative accountability mechanisms, flexibility in procedure to ensure fairness, and enhanced scrutiny of the necessary and proportionality of the impeachment. It was their submission that the office of Deputy President derives its legitimacy from the sovereign will of the people expressed at the ballot under Article 1, and impeachment without proper modification undermines this sovereign will and defeats the legitimate expectation of tenure for both the office holder and the electorate. That Article 38 guarantees citizens the right to elect leaders and to have them serve their full term, subject only to lawful and constitutionally compliant removal process, and that the failure to modify the process resulted in an unjustified interruption of the people's sovereign mandate. Mr. Ndegwa submitted that the Deputy President fell ill during the proceedings while actively engaged in his defense, and that this is not disputed and is recorded in the Senate Hansard. That the Senate refused to grant an adjournment, proceeding instead to a conclusion in his absence, and he submitted that this violated Article 52 on the right to adequate time and facilities to prepare a defense, and Article 52F on the right to be present when being tried, and Standing Order 80 on the right to be heard within Senate proceedings. That a hearing conducted in the absence of the principal defense participant due to verified illness cannot satisfy the conditional threshold of fairness. He stated that the Senate had sufficient procedural latitude under Standing Order 75 to adjourn without violating any constitutional timeline, but the refusal was not dictated by lack of time, but by a failure to exercise discretion fairly. The petitioner submitted that under Article 26 on the right to life, the state must refrain from actions that undermine physical well-being or exacerbate medical vulnerability, and that proceeding with impeachment during illness reduced the Deputy President to a procedural object rather than a rights-bearing participant. They stated that Article 48 on the access to justice extends to all adjudicative processes, including parliamentary impeachment, and that meaningful participation requires reasonable accommodation and denial of adjournment rendered and denial of an adjournment rendered access to justice illusory. They also submitted that the test for bias is objective and whether a reasonable and informed observer would apprehend bias, and that senators acknowledged imperfections in the case but still voted to impeach, which demonstrated bias. They urged the court to address the impeachment process as a whole, not in fragments, noting that the petitioners have demonstrated cumulative defects, including failure to apply the modification rule under 152, absence of impartiality and presence of bias, reliance on irrelevant and extraneous considerations, violations of fair hearing rights, misconstruction of the constitutional and procedural framework, and breach of Standing Order 75, 78, and 80. They submitted that individually, each defect is serious, and collectively, they reveal a process that is constitutionally unsound from inception to conclusion. That Article 165(3)(d) Roman 2 vests the High Court with jurisdiction to determine whether anything done under constitutional authority is inconsistent with or in contravention of the Constitution. They contended that this court is not being invited to interfere with parliamentary politics, but is being invited to perform its core constitutional function as guardian of legality and fundamental rights, and where Parliament acts within constitutional bounds, the court defers, but where it acts outside those bounds, the court must intervene, not as an intruder, but as a constitutional necessity. As such, the petitioners urged the court to find that impeachment was not a measure of last resort when ordinary legal mechanisms were available and bypassed, that the Senate failed to apply the mandatory modification rule under Article 152, rendering the process unconstitutional ab initio, that the refusal to adjourn during illness violated Articles 50, 26, 28, and 48, that the proceedings were infected with bias and irrelevant considerations, and that the cumulative defects render the impeachment null, void, and of no legal effect. They then prayed that their petition be allowed in entirety.
I will then take over from the 51st petitioner's case. Caroline Wambui Mwangi, the 51st petitioner, in the consolidated petitions, filed a petition dated 26th of September 2024 before the High Court of Kenya at Milimani as a public-spirited Kenyan citizen and a defender of the Constitution. Ms. Mwangi contended that the impeachment process was unconstitutional, unlawful, and politically motivated. She relied on public statements allegedly made by Honorable Didmas Baraza and Honorable Gladys Posholei in September 2024, indicating that the impeachment of H.E. Gachagua had already been predetermined, and further referred to a motion by Honorable Danson Mungatana expressing displeasure with the conduct of His Excellency Gachagua. Ms. Mwangi asserted that the allegations leveled against his H.E. Gachagua were vague, unsupported by evidence, and lacking in specificity and peculiarity, contrary to the constitutional requirements of fair hearing and due process under Articles 47 and 50 of the Constitution. She further alleged that the intended impeachment process mounted to a political witch hunt designed to settle political scores rather than a lawful constitutional process, and contended that the respondents had violated the national values and principles under Article 10, including the rule of law, transparency, accountability, equality, and protection of human rights. She maintained that His Excellency Gachagua had not been accorded adequate notice of the charges against him, sufficient particulars of the allegations, nor an opportunity to adduce and challenge evidence in violation of Articles 25C, 35, 47, and 50 of the Constitution. As such, she sought for the following orders. A declaration that within the purview of Articles 25C, 35, 47, and 50 of the Constitution of Kenya, a person facing impeachment proceedings under Article 150 is entitled to be informed substantially with peculiarity and specificity and supported with evidence the grounds of impeachment before the commencement of the impeachment proceedings by the National Assembly and Senate. B, conservatory orders do issue against the respondents, restraining them from a collection of signatures in support of a motion to impeach His Excellency Rigathi Gachagua, lodging any motion and or carrying on proceedings seeking to impeach the Deputy President of the Republic of Kenya, the interested party herein. See, an order of compensation enshrined and provided for under Article 23A of the Constitution of Kenya, made up of damages as shall be assessed and quantified by the petitioner, general damages, cost of the petition, and any other relief. The 51st petitioner neither filed any written submission nor attended the physical highlighting of submissions. In respect to the 54th petitioner's case, Emmanuel Elijah Otieno was the 54th petitioner in the consolidated petitions. He is an advocate of the High Court of Kenya who filed the petition dated 18th of October 2024, together with a supporting affidavit also challenging the constitutionality and legality of the impeachment and removal from office of His Excellency Gachagua as Deputy President. He stated that instituted proceedings in the public interest pursuant to Articles 3 and 258 of the Constitution, and contended that impeachment process undertaken by the National Assembly and the Senate was procedural, unfair, politically motivated, unconstitutional, and inconsistent with the constitutional principles governing impeachment under Articles 145 and 50 of the Constitution. He maintained that impeachment was a constitutional mechanism intended to promote accountability and good governance, and not a tool for settling political disputes or managing political differences among leaders. He challenged the legality of public participation process and the fairness of the proceedings before the National Assembly and the Senate, and the substantive threshold applied in removing His Excellency Gachagua from office. He contended that the National Assembly failed to conduct meaningful and constitutional compliant public participation as required under Articles 10 and 118 of the Constitution and Section 5 of the Fair Administrative Actions Act. Mr. Otieno stated that the public participation exercise was hurried, inadequate, both quantitatively and qualitatively, and incapable of reflecting the sovereign will of the electorate, given that only about 223,000 persons participated, despite His Excellency Gachagua having been elected together with His Excellency President Ruto by over 7 million voters. He further asserted that the public participation template prepared by the National Assembly was biased because it only contained the allegations against His Excellency Gachagua and failed to include his responses, thereby portraying him to the public as guilty before he had been heard. Mr. Otieno additionally stated that the Speaker, Deputy Speaker, and members of the National Assembly demonstrated bias from the outset, failed to accord His Excellency Gachagua a fair hearing, and debated the impeachment motion before proper public participation and before considering His Excellency Gachagua's defense. He maintained that no impeachable offense meeting the constitutional threshold of gross violation, gross misconduct, or commission of crimes under national or international law had been substantiated either before the National Assembly or the Senate. He further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing by proceeding with the impeachment despite his illness and hospitalization, and by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged violations of Articles 25C, 47 and 50 of the Constitution relating to the rights of fair hearing and fair administrative action. He sought the following prayers: A declaration, B, and is hereby issue that the public participation organized and conducted by the first respondent did not meet the requirements of Articles 118, 1B of the Constitution quantitatively and qualitatively. B, a declaration be and is hereby issued that the first respondent violated seventh respondent right to a fair administrative action under Article 47 of the Constitution and Section 4 of the Fair Administrative Actions Act. C, a declaration be and is hereby issued that the first respondent violated the right of the seventh respondent under Article 50, Sub-Article 1 of the Constitution 2010. D, a declaration be and is hereby issued that the resolution of the first respondent to impeach the seventh respondent was invalid and null and void. And E, respondent shall bear the cost of the petition. Likewise, the 54th petitioner neither filed any submissions nor attended the physical highlighting of the submissions. Next is consideration of the 55th and 56th petitioner's case. Stephen Mbugua Wanjiru and Gladys Nyambura Gituha jointly filed the petition dated 20th of October 2024 together with the supporting affidavit sworn by Wambugu Wanjohi. They stated that they were public interest litigants and defenders of constitutionalism. They challenged the legality, constitutionality, and procedural propriety of the impeachment proceedings undertaken against His Excellency Gachagua as Deputy President of the Republic of Kenya, as well as the subsequent nomination and approval process relating to His Excellency Kindiki as the Deputy President nominee. The petitioners contended that the impeachment process before both the National Assembly and the Senate were marred by procedural irregularities, bias, denial of fair hearing, and unconstitutional conduct, that the Speaker and the Deputy Speaker of the National Assembly had publicly pronounced themselves in favor of the impeachment before presiding over the proceedings, thereby violating the constitutional principles of impartiality, neutrality, and natural justice. The petitioners further challenged the adequacy and constitutionality of the public participation exercise conducted on the 4th and 5th October 2024, asserting that the notice period was too short to permit meaningful participation, that the questionnaires used by the National Assembly only presented the accusations against His Excellency Gachagua without his responses, and that the Parliament failed to avail documentary and electronic evidence to the public to facilitate informed participation. He asserted that the Senate proceedings contending he further challenged the Senate proceedings, contending that the Senate violated His Excellency Gachagua's right to a fair hearing, proceeding with the impeachment despite his illness and hospitalization, by failing to adjourn the proceedings to allow him an opportunity to personally testify. He therefore alleged that Sorry, I had repeated that bit, but I'll put from 3. They additionally alleged that public participation process was chaotic, disorderly, and marred by violence and characteristic consequences taken on days when many Kenyans were engaged in religious worship, thereby undermining the constitutional threshold for meaningful participation under Articles 10 and 118 of the Constitution. The petitioners also challenged the conduct of the Senate. They contended that the Senate acted in violation of Articles 25C, 47 and 50 of the Constitution by refusing to adjourn the impeachment hearing His Excellency Gachagua's illness and hospitalization, thereby giving him an adequate opportunity to personally defend himself. Alleged bias and conflict of interest, passion of Governor James Orengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, in the Senate proceedings, stating that their rules compromise the fairness and impartiality of the impeachment process. The petitioners maintained that the impeachment proceedings before both houses of Parliament were characterized by constitutional violations, procedural inconsistencies, and disregard for due process. The petitioners also challenged the subsequent nomination and approval of His Excellency Kindiki as Deputy President, contending that the nomination was tainted by the same constitutional and procedural violations that affected the impeachment process and was therefore null and void. As such, sought the following prayers: a declaration that the grounds of impeachment laid in the special motion dated 24th of September 2024 did not meet the constitutional and legal threshold for impeachment of a deputy president. That a declaration do issue that public participation exercise conducted on the 4th and 5th of October was flawed and incapable of meeting the constitutional standards required for such processes, and the outcomes of this flawed participation do not reflect the will of the people and cannot be considered a legitimate basis for advancing the impeachment motion. See a declaration that the impeachment process against the Deputy President initiated by the National Assembly and subsequently conducted by the Senate was tainted by substantive and procedural constitutional violations, rendering unconstitutional, illegal, null, and void. D, an order nullifying the impeachment of the Deputy President as the process was marred by procedural irregularities, bias, conflict of interest, and a violation of the right to a fair hearing as guaranteed under Article 50 of the Constitution. A, an order directing the immediate reinstatement of the Deputy President to his duly elected office, having been unconditional and constitutionally and unlawful removed through an impugned process. F, an injunction restraining the President, the National Assembly, and any other state organs from proceeding with or effecting the appointment of any other person to the office of the Deputy President pending the hearing and determination of this petition. G, an order revoking the nomination and subsequent approval of Professor Kithure Kindiki as Deputy President by the National Assembly, as it stems from an unconstitutional process and is procedurally flawed and in violation of the Constitution. H, a mandatory injunction directing the National Assembly and the Senate to comply with the Articles 10 and 118 of the Constitution by ensuring meaningful and effective public participation in any future impeachment processes or similar proceedings of national importance. I, Declaration Sorengo, Senior Counsel, and Honorable Otieno Molo, Senior Counsel, in the impeachment proceedings violated the principles of impartiality and fair hearing and constituted a conflict of interest that compromised the integrity of the impeachment proceedings. J, an order awarding the petitioner cost of this petition, and K, any other orders or reliefs. The 55th and 56th petitioners did not file any written submissions, and they also did not turn up at the hearing. The 57th petitioner was Edwin Gekonge, and he filed the amended petition dated 23rd of October 2024 before the High Court of Kenya at Mombasa, together with their supporting affidavit on the of the same date. He stated that he is a law-abiding citizen, human rights defender, and a public-spirited litigant acting in his own interest and in the interest of citizens of the Republic of Kenya. The petition challenged the constitutionality of the impeachment proceedings undertaken against His Excellency Gachaguas as Deputy President, as well as the subsequent nomination and approval of His Excellency Kindiki as the Deputy President. He stated that the impeachment proceedings for the violated 32 and 150 of the Constitution, that the public participation October threshold of effective, meaningful, and inclusive public participation. The petitioner asserted that the notice period for the public participation exercise was too short, that the exercise was limited to county offices instead of constituency level, and that the extension of the exercise to 5th of October 2024 was ineffective because the notice was issued on the very day of participation and coincided with a Sabbath day of worship for the Seventh-day Adventists, thereby excluding members of the faith from meaningful participation. He further alleged that the exercise was marred by confusion, violence, inadequate information, early closure of centers, and generally low participation, thus violating Articles 10 and 118 of the Constitution. He also challenged the legality of the Senate proceedings on the ground that His Excellency Gachagua was denied a fair hearing contrary to Article 50 of the Constitution. He contended that although the first petitioner had fallen ill and was unable to continue participating in the proceedings, the Senate declined to adjourn the hearing and proceeded to vote on the impeachment charges in his absence. Mr. Gekonge stated that Article 145 of the Constitution did not prescribe rigid timelines that could override the constitutional right to a fair hearing, and that the Senate failed to apply the necessary constitutional modifications contemplated under Article 150 in impeachment proceedings relating to a deputy president. He further maintained that the evidence presented before the Senate did not attain the constitutional threshold required to establish gross violation of the Constitution, gross misconduct, and serious reasons to believe that His Excellency Gachaguas committed crimes under national law. Mr. Gekonge also challenged the legality and constitutionality of the nomination and approval of His Excellency Kindiki as Deputy President, stating that the constitutional timelines under Article 149 contemplated meaningful public participation and adequate vetting before approval of a Deputy President nominee. He contended that His Excellency Kindiki remained a state officer serving as Cabinet Secretary at the time of nomination and had not formally resigned, thereby rendering him constitutionally disqualified under Article 137 and Sections 23 and 24 of the Elections Act. The petitioner further challenged the role of IEBC, contending that the Commission was not properly constituted and therefore incapable of lawfully confirming the qualifications of the nominee. Mr. Gekonge sought the following orders. A declaration that the modalities put in place by the first respondent in respect of the public participation forums that were scheduled for the 4th and 5th October 2024 regarding the special motion fell below the threshold of a proper, effective, and meaningful public participation as envisaged under Article 10 of the Constitution. B, a declaration that the public participation process on the 5th of October 2024 was unconstitutional for failure to provide sufficient notice and in violation of the freedom of religion under Article 30, under Article 32. C, a declaration that the impeachment process against the first interested party undertaken by the first and the second respondents was unconstitutional and did not meet the requirements set under Articles 145 and 150 of the Constitution of Kenya. D, a declaration that the impeachment process
The Voto's acne removal, effortless precision with a simple slider. Navigate to
third respondent was unconstitutional as it violated Article 50 of the Constitution of Kenya in terms of providing a fair hearing. E, a declaration that the impeachment proceedings of the first interested party taken by the first and third respondent was unconstitutional, void for failing to meet the evidential threshold of the impeachment of a deputy president under Article 150, subarticle 1B. F, a declaration that the nomination of Abraham Kithure Kindiki by the President of Kenya is unconstitutional, null and void, and in contravention of Article 137(1) of the Constitution. G, a declaration that the approval of the nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional for failure to comply with Articles 10 and 118 of the Constitution. H, a declaration that the approval of the nomination of a deputy president of the Constitution must include public participation in every constituency. I, a declaration that the approval and nomination of Abraham Kithure Kindiki by the National Assembly is unconstitutional as Abraham Kithure Kindiki had not resigned as a state officer. J, a declaration that the independent, that IEBC at the time of nomination of Abraham Kithure Kindiki was not properly constituted to approve or confirm the qualification of Abraham Kithure Kindiki under Article 137(1) of the Constitution. K, a declaration that IEBC had violated Article 149 of the Constitution by confirming that Abraham Kithure Kindiki was qualified to stand as a member of Parliament as per Article 137(1) of the Constitution. L, any other orders as the court may deem just. Mr. Gekonge likewise did not file any submissions. In respect of the 50th, the 52nd and the 53rd petitioners, that is John Njomo, Clarence Eboso, and Wanjiru Mwangi, their petitions were withdrawn from the consolidated proceedings on the 7th November 2024 as well as on the 16th of May, 2025. On the 7th interested parties case and submission, that is Kituo cha Sheria, it appeared as the 7th interested party in these proceedings and filed a replying affidavit sworn on the 15th of April 2026 by Dr. Wambua Kituku, who is its executive director, as well as written submissions of even debt. Kituo identified 4 issues for court's determination, being whether the National Assembly process met the constitutional threshold for meaningful public participation and Articles 110, 110 and 118 of the Constitution. Secondly, whether impeachment proceedings were quasi-judicial to the extent that they met constitutional and statutory procedural fairness standards. Thirdly, whether the court could review the procedural regularity of impeachment proceedings consistently with the doctrine of separation of powers. And lastly, whether the refusal to adjourn and the decision to proceed with in absentia violated the first respondent's petitioner's right to fair administrative action and fair hearing under Articles 10, 27, 28, 47, and 50 of the Constitution. Kituo cha Sheria averred that Article 118 of the Constitution mandated Parliament to facilitate public participation and involvement in legislation and all other business of the Assembly and its committees. They further argued that the removal of a deputy president from office was one of the most significant constitutional functions assigned to the National Assembly and the Senate and directly affected the sovereign will of the people. It was their understanding that public participation in such a constitutional process had to be both quantitative to mean that a sufficient number of citizens had to be reached and accorded an opportunity to participate, and qualitative to mean that the participation had to be meaningful and capable of influencing the decision-making process. Kituo further averred that the one-day public participation notice given by the Speaker of National Assembly and the National Assembly itself was inadequate to reach a substantial portion of the Kenyan population, particularly ordinary citizens who relied on accessible and localized communication channels. They deposed that the said notice did not necessarily reasonably reach rural communities, citizens without access to national media, citizens relying on vernacular radio stations, and those who depended on local public fora for information. He stated that National Assembly reduced 290 potential local hearings to only 47 hubs for public engagement forums, including venues such as Kiambu Social Hall, Gatundu, Nakuru ASK Shule, and Tomboya Labour College, thereby drastically limiting accessibility and diluting representation. Kituo cha Sheria averred that the National Assembly and the Senate did not take adequate steps to ensure that sufficient citizens were made aware of the intended impeachment process. In particular, they had failed to disseminate information through churches, mosques, temples, public barazas, community meetings, vernacular radio stations, and county-level public participation forums. They further averred that the alleged public participation conducted by the National Assembly and the Senate lacked adequate structures for public engagement, including ICT-based platforms for the submission of views, decentralized citizens forums, structured mechanisms for receiving memoranda from citizens across counties, and organized town hall meetings. As a result, members of public were largely reduced to observers of the proceedings rather than participants in the process. They deposed that in the impeachment proceedings conducted by the Senate, by the Speaker of the Senate and the Senate on the 16th and 17th of October, His Excellency Gachaguas was denied an opportunity to appear and be heard, to be present when being tried, and to challenge the evidence. That during the proceedings on the material day, it was communicated to the Speaker of the Senate, and the Senate, that is Excellency Gachaguas, was present but subsequently fell ill. He was then rushed to hospital for urgent medical attention, and his legal counsel duly communicated his admission to hospital to the Speaker. Notwithstanding the request for adjournment on this ground, the Senate declined the request and proceeded to hear the case in the absence of His Excellency Gachaguas and his counsel. The Senate subsequently decided to remove His Excellency Gachagua from office by impeachment for gross misconduct and on grounds of violation of the Constitution. Kituo stated in the proceedings of that the proceedings of the removal from office of the Deputy President before the Senate involved the reception of evidence, evaluation of contested facts, and the making of determinations that directly affected the fundamental rights of His Excellency. Those proceedings, therefore, ought to have been procedurally fair and to have accorded him an opportunity to be present during the trial, to be cross-examined, to be re-examined, and to fully clarify any allegations made. However, the Senate, in disregard of the quasi-judicial nature of the proceedings, reached its determination without affording His Excellency those rights. Kituo cha Sheria contended that declining an adjournment request when His Excellency suffered severe and involuntary pain constituting a medical emergency was inhumane and unreasonable. They further averred that the one-day public it was further averred that the Senate, as a state organ, was bound to follow the Constitution and to observe, respect, protect, promote, and fulfill His Excellency Gachagua's rights. That upholding the impeachment as conducted set a dangerous precedent by normalizing procedural shortcuts in constitutional processes and weakened safeguards meant to protect constitutionalism and the respect for the rule of law. The absence of cross-examination in the present case was, in his view, a novel and serious procedural omission that contravened national values and principles of governance, including good governance, integrity, transparency, accountability, fairness, human dignity, equality, social justice, inclusiveness, equality, human rights, non-discrimination, and protection. They expressed their belief that the court had a solemn duty in interpreting the Constitution to adopt a purposive and progressive approach that advanced good governance, constitutionalism, accountability, and public interest. They further averred that the determination of the petition would provide critical guidance on the constitutional standards applicable to future impeachments of holders of the offices of the Deputy President and the President, and that it must therefore reinforce rather than dilute the public participation threshold and fair hearing protections. Kituo submitted that the standard for public participation envisaged under Article 118 was meaningful participation and not tokenism, and that it had to be assessed on reasonableness and meaningfulness and meaningful opportunity, considering the nature and the impact of the decision. It was submitted that the removal of a Deputy President from office was not an ordinary procedural matter, but constitutional event with profound democratic implications. That Article 118 had to be read together with Articles 1 and 10 of the Constitution, and that sovereign power belonged to the people, and Parliament merely exercised that power in a delegated capacity. When Parliament embarked on a process that might remove from office a Deputy President who was directly elected by the people, it was obliged to ensure that the people themselves were accorded a meaningful opportunity to be heard. It was further submitted that in such a context, public participation became a constitutional condition precedent to valid impeachment processes. The organization submitted that public participation in a constitutional democracy had to satisfy both quantitative and qualitative standards, and that this dual requirement was particularly important where the process concerned the removal of a nationally elected office holder. In support, they relied on the Mwangaza versus Speaker of National Assembly case, in which the court stated that public participation was a constitutional requirement, and Articles 10(2)(a) and 190 sub-Article 1(b) of the Constitution mandating inclusive and meaningful citizen engagement in government decision making, including legislative processes such as impeachment. It was further submitted, relying on the case of Wambora, that the Constitution did not intend a scenario where an otherwise popular Deputy President could be removed due to political rivalry, malice, vendetta, institutional tough wars, and partisan hostility within government, and that public participation acted as a constitutional safeguard against the abuse of impeachment powers. On the inadequacy of the notice period, the interested party submitted that the one-day Gazette notice and a national radio announcement coupled with two-day public engagement period was grossly inadequate to facilitate meaningful public participation, as such short time could not reasonably reach most Kenyans, particularly ordinary citizens who relied on accessible and localized information channels. On the over-centralization of venues, they submitted that the Speaker of National Assembly and the National Assembly failed to utilize several well-established participatory mechanisms ordinarily available to them, including ICT platforms for structured public input, county-based citizen engagement forums, public notice boards, and accessible announcements, town hall meetings, engagements through representation of the people, and decentralized partisan platforms across counties. Instead, the National Assembly adopted a centralized and restrictive mode whereby all 290 constituencies were grouped into only 47 participation centers, one per county. This arrangement overloaded single venues, diluted constitutional high-level representation, and transformed public hearings into mass gatherings where individualized contributions were particularly impossible. The structural barriers disproportionately undermined meaningful engagement, especially for marginalized communities, people with disabilities, workers unable to leave employment on short notice, those without transportation, and citizens living far from county headquarters. It was submitted that a process of this gravity required decentralized, not consolidation of engagement forums. On the rigid and non-deliberative format of engagement, they submitted that the National Assembly employed a highly structured and restrictive model of engagement in which parliamentary clerks read out the charges, provided a general explanation of the processes, attendees were given limited time to offer their views, and those views were recorded in a pre-designed format for compilation. That format did not allow robust deliberation, did not permit cross-examination of claims, and did not facilitate informed submissions on the constitutionality or factual basis of the impeachment. It was submitted that public participation had to be interactive and not merely a formalistic exercise. On the inadequacy of the online submission mechanism, they submitted that the National Assembly's website provided template forms where citizens could tick boxes indicating support or opposition to the impeachment, but those forms offered only binary choices, allowed no uploading or supporting documentation, and permitted no opportunity for dialogue or nuanced analysis. This reduced public participation to checkbox voting rather than substantive constitutional engagement. They acknowledged in their submissions that the standard required was not perfection but reasonableness. However, reasonableness is in a matter of this magnitude required the Speaker of the National Assembly and the National Assembly to have actively mobilized public awareness through non-public convergency points such as churches, mosques, temples, public barazas, national radio stations, vernacular, other accessible civil forums. The failure to which those avenues significantly restricted the reach of the notice and consequently diminished participation. The process was submitted to have been conducted on an extremely short notice, centralized into two field venues, and structured in a rigid and non-deliberative manner, and procedurally shallow through form-based engagement, all of which demonstrated a failure to meet constitutional standards and calling into question the validity of the impeachment of His Excellency Gachaguas. It was further submitted that the removal of a deputy president from office was not merely an internal matter of parliament, but a matter of national constitutional significance affecting the democratic will of the electorate, the integrity of the executive structure, the political stability of the Republic of Kenya, and the sovereignty of the people, and that accordingly the electorate had to be accorded an opportunity to participate in a process that sought to overturn their democratic choice. Kituo cha Sheria submitted that even where Parliament acted within its constitutional mandate, when it undertook a process that received and evaluated evidence and reached determinations adverse to rights, reputations, and the tenure of office, it was obliged to meet minimum content on procedural fairness. It was submitted that the Senate proceedings bore all the hallmarks of a quasi-judicial trial, from pleadings, evidence, contested facts, and was finding to a grave sanction in the form of removal from office, and that Articles 47 and 50 of the Constitution and the Fair Administrative Actions Act 2015 therefore applied with full force. Impeachment of a national executive was not a mere political debate, but a structured constitutional trial with legal standards burdened with reputational, civil, and democratic consequences, which made the rights to be present, to cross-examine, and to be re-examined all the more imperative. It was submitted that Article 50, read together with Article 25C of the Constitution, and that scored that fair trial rights were non-derogable in substance, relying on Stephen Odede versus Court Maxwell, in which the court confirmed that the right to a fair hearing and right and fair trial ought not to be unduly impeded, and that a trial body had to be circumspect in purporting to limit and take away such crucial rights, since Article 25C specifically provided that there was never to be any derogation from the right to a fair hearing. It was further submitted that while impeachment was sui generis, the logic of adversarial testing of allegations applied with equal, if not greater force. His Excellency Gachaguas fell ill, was admitted for urgent medical care, and his counsel sought an adjournment, which was refused. The Senate proceeded in absentia without counsel, received and assessed evidence, and removed him from office, thereby extinguishing his ability to be present, to be cross-examined, and to be re-examined, and to participate meaningfully. It was submitted that a fair process entailed reasonable accommodation, including adjournment, where good cause was shown and no prejudice will be suffered that could not be compensated by way of cost or by way of time. Kituo cha Sheria relied on Githiga and 5 others as a security factory company limited, in which the Supreme Court confirmed that the right to a fair trial indicated that the right to a fair hearing indicated that an individual shall not be penalized by a decision affecting his rights or legitimate expectation unless he had been given prior notice of the case against him, a fair opportunity to answer, and the opportunity to present his case. It was submitted that this was precisely what was not accorded to His Excellency Gachaguas. It was further submitted that if the Senate could adjourn an entire sitting over quorum issues as per Standing Order 40, then refusing to adjourn to accommodate a hospitalized party where fairness and due process rights were under Articles 47 and 50 were at stake was unreasonable, disproportionate, and constitutionally infirm. They argued that the right to be heard required a real...
My work is easy because I use ClickUp. Here's how I get perfect notes from every meeting. I click this toggle to send my AI note taker to my meetings, even if I can't attend. My AI note taker records the entire meeting and creates a full transcript. After the meeting, I get a doc with the recording, takeaways, and even the action items. AI turns these action items into tasks so we actually get things done. ClickUp makes work easy, from personal projects to running a multi-billion-dollar company. Click the link below to create your workspace for free.
Of the right to be heard. The Senate could have proceeded in His Excellency Gachaguas' absence if his conduct had made it impossible to continue the hearing, or if, after due notice, his notice was unjustified. In the present case, they submitted that that absence was explained as a medical emergency, and counsel had sought an adjournment. Proceeding to receive and evaluate adverse material in those circumstances, His Excellency Gachaguas' ability to participate meaningfully was impugned. It was further submitted that in impeachment, the public interest was best served by accuracy and fairness, not speed for its own sake, and that where adverse oral evidence was received and weighed, cross-examination was then crucial for testing credibility, the denial of which hollowed out fairness and tainted the decision. It was submitted that expedition could not cannibalize fairness, and that Articles 10, 47, and 50 demanded reasonable accommodation, especially where a short adjournment would have cured the prejudice occasioned by a medical emergency. Kituo cha Sheria submitted that courts had emphasized committee and institutional respect, and that impeachment was principally a political and constitutional accountability process, but that Parliament had not been insulated from judicial scrutiny where constitutional requirements were breached. Relying on the Mwangaza case, Kituo cha Sheria recalled the court's pronouncement that impeachment was an invaluable safeguard against impunity and an abuse of office that had to be jealously protected and must not be allowed to become an avenue for fighting political proxy wars or resurrecting ballot box contestations. The court further stated that the court further stated therein that watering down impeachment, lowering its bar too low, or allowing it to become a facade, masking hidden political interests, ran the risk of Kenyans losing confidence in the process, and that the intervention of courts came far down the impeachment path, making it the duty of the primary duty bearers to ensure that impeachment remained a constitutionally envisaged. Kituo cha Sheria submitted that constitutional review was therefore available to term procedural impropriety in the exercise of public power, even in political charged arenas. Further reliance on the relying on the Wambora case, Kituo cha Sheria recalled the Court of Appeals statement that the process of removal lay entirely in the County Assembly, wherein it was initiated, and the Senate, wherein it was concluded, but that the court might only come in when necessary to confirm that the process had been properly followed as laid down in the Constitution and the statute. Accordingly, they submitted that the question before the court was not how the Senate should have voted, but whether it had obeyed the Constitution in getting there. It was submitted that Article 10 of the Constitution bound all state organs, whenever they applied or interpreted the Constitution, or enacted, applied, or interpreted any law, or made or implemented policy, public policy decisions, and required good governance, integrity, transparency, accountability, human dignity, equality, social justice, inclusiveness, equality, human rights, and non-discrimination. An impeachment that shut out the subject's presence, cross-examination and re-examination, especially in a medical emergency, subverted human dignity, equality of arms, and accountability, and was thus unconstitutionally infirm. Kituo cha Sheria was not asking the court to supervise the National Assembly and the Senate debate or to substitute their judgment, but only to ensure that in reaching their determination, the constitutional procedures were observed. They sought a declaration that the impeachment proceedings conducted on the 16th October 2024 by the Senate were procedurally unfair, unconstitutional, and ultra-vires. A declaration that the Senate, acting as a quasi-judicial body, violated Articles 47 and 50 of the Constitution by denying cross-examination, re-examination, and a reasonable adjournment in the alternative. A reasonable adjournment. In the alternative, if the court was minded to preserve the proceedings, an order of remit directing the de novo hearing before the Senate in strict conformity with constitutional and statutory fair hearing requirements, including presence, representation, examination, disclosure, and reasonable determination, and such other orders as the court may deem fit to vindicate the Constitution and the public interest in a lawful, rational, and fair impeachment process. Kituo cha Sheria concluded its submissions by urging the Constitution that the Constitution erected procedural safeguards precisely because impeachment was a constitutional earthquake, where the Senate refused a short adjournment despite His Excellency Gachaguas' hospitalization, proceeded in absentia, and delivered the ultimate sanction without the presence, cross-examination, and re-examination of the accused. The process failed the constitutional test. It was submitted that this court ought to intervene not to rewrite politics, but to enforce procedure, and in so doing, preserve Kenya's commitment to the rule of law, constitutionality, accountability, and human dignity. We'll now proceed to responses and submissions to the consolidated petitions. We'll start with the second and the seventh respondents' cases. The National Assembly and the clerk to the National Assembly were the second and the seventh respondent in the consolidated petitions. They jointly responded to the petitions through a replying affidavit sworn by its clerk, Samuel Joroge, on the 9th of October 2024 and the 21st of October 2024, and the grounds of opposition dated 4th of October 2024. They asserted that the impeachment process was entirely constitutional, lawful, and procedural fair, and that all actions were taken, all actions taken complied with Articles 145, 150, and 118 of the Constitution, as well as the National Assembly standing orders, as well and the court directives. They further posited that the impeachment of the Deputy President followed Article 150, Sub-Article 2 of the Constitution, which applies Articles 144 and 145 of the for the President with necessary modification, and that Standing Order 65-2 of the National Assembly explicitly states that Standing Order 64 applies to the Deputy President with necessary modifications as well. They deposed that the Speaker validly confirmed that the motion met the required legal form and the signature threshold of at least 117 MPs, or 1/3 of all members, that public participation was adequate, inclusive, and compliant with court orders, as the National Assembly placed advertisements in all three national dailies on the 2nd, 3rd, and 4th of October 2024. Public hearings were held on the 4th of October 2024 across the country, and that public the public will submit views by way of email, post, hand delivery. A dedicated template in English and Kiswahili was provided, and they were also able to visit the constituency offices. The respondents contended that upon being served with a court order on the 3rd of October 2024, they extended public participation to the constituency level until 5th of October 2025, and that a public participation report was published. They asserted that the process was real and not illusory, that public participation was not part of the Deputy President defense, as it was meant to gather general public views to inform the Assembly, and that holding it first preserved the integrity and the independence of public input, preventing it from being influenced by the Deputy President's defense or parliamentary debate. The respondents maintained that the Deputy President still received his full right to be heard during the debate on the 8th of October 2024, where he appeared in person with his legal team. The respondents further claimed that one of the petitioners, Honorable Jane Jeremiah, closed her Kirinyaga County Women Representative Office during public participation exercise, despite parliamentary officers being deployed there. Further, they reliably learned that the closure was directed by the woman representative herself, since she was vehemently opposed to the impeachment. The respondents averred that she cannot then benefit from her own actions that obstructed the public participation exercise. The respondents deposed further that after debate on the 8th of October 2024, the motion was put to a vote, and 282 members voted in support of the impeachment and 44 voted against, which exceeded the required 2/3 majority under Article 145(2) of the Constitution. That on the 9th of October 2024, the Speaker of the National Assembly formally notified the Speaker of the Senate of the resolution by transmittal. The respondents denied any constitutional or otherwise wrongdoing and prayed that the constituted petitions against the National Assembly and the clerk be dismissed with course. In respect to their submissions, the National Assembly and its clerk's onslaught on the constitutional petition was led by learned counsel Mr. Eric Gumbo, Mr. Paul Nyamodi, and Honorable Gitonga Murugara. They identify the following issues for this court's determination. A, what is the extent of this court's jurisdiction to hear and determine the consolidated petitions relating to the impeachment of His Excellency Gachagua? B, whether the sub judice rule under Standing Orders 89 and 103 of the National Assembly and the Senate Standing Orders bars parliamentary proceedings on impeachment where judicial proceedings are pending. C, whether the impeachment proceedings before the National Assembly were valid. D, whether the petitioners have demonstrated any valid grounds for challenging the impeachment proceedings conducted before the Senate. E, whether the impeachment unconstitutionally subverted the sovereign will of the electorate expressed in the 2022 general elections contrary to Articles 1, 2, and 38 of the Constitution. F, whether the nomination, approval, and appointment of Honorable Kindiki as the Deputy President was invalid, and whether the petitioners are entitled to any of the reliefs sought. The National Assembly and clerk submitted that the impeachment of His Excellency Gachagua as Deputy President was constitutionally valid, procedurally proper, and politically necessary to uphold accountability and the rule of law. They also defended the subsequent nomination, approval, and appointment of Honorable Kindiki as Deputy President as fully compliant with the Constitution. Their positions remained that an impeachment is a political process, not a judicial one, and that the Constitution vests sovereign power in the people exercised through their elected members under Article 1, that the Constitution mandates public participation of strict timelines and bicameral supermajority representation requirements of the 2/3 in both houses, making the impeachment framework rigorous and transparent. They submitted that the comparative analysis with the United States, Philippines, Brazil, South Korea, and Nigeria shows that Kenya's process aligns with global presidential systems where impeachment is a constitutional safeguard against abuse of office. On the High Court's jurisdiction under Article 165 of impeachment proceedings, they submitted that such power is only residual and supervisory, not appellate. That impeachment is a political process entrusted to Parliament, and courts should not interrogate the substantive merits of impeachment charges. They added that the court's role is limited to ensuring procedural compliance and protection of individual constitutional rights, and citing the cases in Wambora and Sonko. They asserted that the courts must show deference to Parliament in matters where the Constitution grants Parliament discretion. Learned counsel also cited the decision in the Supreme Court of Philippines in Re Sara Duterte, which similarly held that courts will not encroach on co-equal branches on political questions. It was their further submission that Standing Order 89 of the National Assembly and 103 of the Senate do not absolutely bar discussion on matters pending in court, and a matter is sub judice only if discussion is likely to prejudice fair determination of active proceedings. They stated that the petitioners did not raise any sub judice objection during the parliamentary proceedings, and they cannot raise it now. The National Assembly and clerk submitted that the Constitution itself imposes tight timelines under Article 145, that is 2 days to notify Senate, 7 days to convene a Senate, and 10 days for the committee investigation. They contended that impeachment is urgent, as prolonged proceedings will cause political uncertainty and undermine governance. The standing order were a legitimate excess of parliamentaries' power under Article 124 to regulate its internal affairs, and that timelines are constitutionally anchored and not subject to judicial invalidation, as was held in Mbarak Issa Kombo's case. It was their further submission that public participation was adequate, as the National Assembly issued notices in the Kenya Gazette, national newspapers, news website, and social media on the 2nd, 3rd, and 4th of October 2024. Public hearings were held at county and constituency levels, including compliance with Justice Mwongo's order on constituency level participation, and 223,083 citizens submitted views, which they stated was an unprecedented level of civic engagement. Further, that the public views template was provided in English and Kiswahili. Submissions were received orally, in writing, and electronically. They also submitted that the constitutional standard is reasonableness, not perfection, and that the Supreme Court and Cabinet Secretary for National Treasury and Planning and 4 others versus Okoita and 52 others held that timelines must be considered when assessing public participation adequacy. They submitted that His Excellency Gachaguas' response was not required to be circulated simultaneously, as the public role is to express views, not adjudicate, and that allegations of violence, intimidation, and poor organization were unsubstantiated, and that isolated incidents do not vitiate an entire process. They also submitted that public participation report was submitted in Parliament and recorded in the Hansard, which is a valid parliamentary record. They stated that the impeachment motion was properly particularized and set out 11 detailed grounds with specific particulars, and that these grounds met the threshold set in the Wambora's case of being serious, substantial, weighty, with clear nexus and precise constitutional provisions. That the motion was supported by 282 MPs, which was well above the 2/3 requirement of 233 MPs, and that the Deputy President was accorded a fair hearing, as he received prior notice of the charges. He filed his written response and appeared in person with counsel, and he was given 2 hours to address the National Assembly. The National Assembly and the clerk also submitted that His Excellency Gachagua's defense was considered and debated before the vote, and that the 2/3 gender articles 97 and 98 on the composition of Parliament have been fully complied with. On the 2/3 gender principle under Article 81B, it was submitted that this was an aspirational provision to be achieved progressively, not a condition precedent to Parliament's validity, and that Article 261 provides a mechanism for addressing legislative delays, and that no advice from the Chief Justice or action by the President has occurred to dissolve Parliament. They contended that accepting the petitioner's argument would void all legislation and action since 2013 and will be an absurd and constitutionally impermissible outcome. On the allegation of bias against the Deputy Speaker, they submitted that allegations were unproven, and further that the Deputy Speaker only performed administrative and procedural functions and that she did not vote. Further, no recusal motion was raised during the proceedings. They stated that the test for bias is objective, as stated in the Supreme Court in Rawal and others, and that the threshold had not been met in this matter. Council added their voice to the position that the Senate handled the impeachment hearings by hearing the charges in plenary, since Article 145, Subarticle 3A, mandates the Senate to convene and hear such charges. That Article 145, Subarticle 3B, uses the word may, and therefore the appointment of a special committee was discretionary and not mandatory, and the semicolon and in Article 145, Sub-Article 3, do not convert the discretionary power into a mandatory obligation. They reiterated that the Senate motion to appoint a special in plenary. They relied on the Supreme Court Court and Sonko case that confirmed that for governors, the Senate may proceed in plenary or by committee, and that the same applies to the deputy president. It was also their submission that the 10-day timeline for plenary proceedings was constitutional, as where the Constitution is silent, the Senate may regulate its own procedures under Article 124, Sub-Article 1, and the 10-day deadline was a reasonable exercise of procedural autonomy to ensure expedition. Council submitted that impeachment must be concluded without undue delay, and the timeline reinforced accountability and good governance. It was their father's position that His Excellency Gachaguas received a fair hearing in the Senate, as he was represented by counsel throughout. He was cross-examined at the National Assembly, and he cross-examined National Assembly witnesses, and he filed witness affidavits on the 12th and 13th of October 2024. They contended that the Senate did not refuse an adjournment unreasonably, as senior counsel Muite was given from 2:30 p.m. to 5 p.m. to contact His Excellency Gachaguas, that no medical evidence of either a doctor's report or prescription was provided to the Senate, and that the Senate offered to adjourn until Saturday, 19th, October 2024, within the constitutional time frame, but this motion failed on a vote. The National Assembly and the clerk submitted further that the decision to proceed in absentia did not violate fair hearing, as His Excellency Gachaguas had already filed his evidence and opted out after cross-examining the National Assembly's witnesses. That no new evidence was introduced. All material before the Senate had already been placed before the National Assembly and forwarded to the Speaker, and time allocation was not disproportionate, as both parties were accorded equal time. The National Assembly submitted that it also could not call all its witnesses due to time constraints, and that this was a consequence of expedition and not bias. They further submitted that the Senate had no independent duty to conduct public participation, which under Articles 10 and 118 applies primarily to legislative functions. The Senate, when hearing impeachment, acts as a quasi-judicial capacity, not a legislative one, and that public participation occurs at the National Assembly during the initiation stage, not at the Senate at the trial stage. Council submitted that comparative practice in South Africa, USA, and in the USA, Nigeria, and Brazil confirms that the upper house role is adjudicatory, not participatory, and that the court in Mwangaza versus Speaker of the Senate held that public participation in gubernatorial impeachment occurs at the county assembly level, and the same applies in equal measure in this matter. The respondents contended that allegations of bias against the Senate Speaker remained unproven, as a Speaker's role is presiding and procedural, and he has no deliberative vote. That mere coalition membership does not establish bias, and that the petitioners have not pointed to any specific act or omission showing a real possibility of bias. They restated that the test for bias is objective, and the petitioners failed to meet it, as well as in respect of the Senate Speaker. It was the submission of the National Assembly and the clerk that the participation of Honorable Orengo and Honorable Amolo as counsel did not invalidate the proceedings, in that Article 77(1) restricts gainful employment that is inherently incompatible with state office, and that representing a party in proceedings is not such an employment. That any alleged illegality would affect the advocates personally and not the validity of the impeachment process, and that no actual bias or procedural fairness has been shown. They further submitted that the Senate applied the correct standard of proof for impeachment, which is above a balance of probabilities but below beyond reasonable doubt, as set out by the Supreme Court in the Sonko and Wambora cases. The Senate found 5 charges substantiated, including gross constitutional violations, attacks on judicial independence, ethnic incitement, gross misconduct, and that the evidence was substantial and credible, including His Excellency Gachaguas' own public admissions. Learned Counsel submitted an urge that the court should not undertake a merit review of the Senate findings. Counsel reiterated that impeachment does not subvert the sovereign will of the people, as it is not an affront to democracy, but an affirmation of accountability. That the Constitution provides for removal of elected officials for gross misconduct, constitutional violations, and crimes, and that the joint ticket of the President and the Deputy President does not create legal inseparability, as they are separate constitutional offices with distinct and accountability mechanisms Counsel gave comparative analysis of the U.S. Vice President resignations while President Nixon remained, and Brazil's President Rousseff's impeachment while Vice President Temer assumed office when they submitted that removal of deputy does not require removal of the principal. They contended that Article 150 of the applies Article 145 with necessary modifications, and that this acknowledges that distinct offices are not a merger. On the validity of His Excellency Kindiki's nomination, approval, and appointment, the National Assembly and the clerk submitted that a lawful vacancy arose by operation of law under Article 145(7), as the impeachment was valid. IBC clearance was not constitutionally required for a deputy president nomination under Article 149, and that the president merely sought information of the voter registration status and MP qualifications from IBC as a matter of prudence. Council submitted that IBC Secretariat acted within administrative mandate by providing information which is not commission-led constitutional function. Council referred this court to the Supreme Court advisory opinion in IBC versus AG 2025, where it drew a distinction between commission-led functions such as boundary delimitation and secretariat administrative functions, including the day-to-day operations. They submitted that providing information falls within the latter. It was their submission that His Excellency Kindiki met constitutional qualifications for appointment, as is a Kenyan citizen by birth, qualified to be an MP and nominated by a political party, UDA, thus satisfying Article 137 as read with Article 148, and that his party membership was properly documented with the register of political parties. They contended that allegations of misconduct during His Excellency Kindiki's tenure as Cabinet Secretary were mere allegations, and that no judicial or quasi-judicial finding of culpability exists, and that the court in International Center for Policy and Conflict and 5 others versus AG, reported 2013, held that unproven allegations cannot disqualify a candidate. That holding a cabinet secretary position did not disqualify him under Article 77, as this provision prohibits gainful employment that creates a conflict of interest, but does not bar a state officer from seeking elective office. The Council submitted that disqualification for holding state office is governed by Article 137, Subarticle 2B, that requires resignation 6 months before a general election. But it is not applicable to a mid-term vacancy, which process under Article 149 is sui generis. The National Assembly submitted that the voting process complied with Article 149(1), which requires the National Assembly to vote on the nomination, which is an electoral determination by plenary, not an approval process requiring committee vetting, that the Speaker correctly distinguished between appointive officers subject to committee approval and the elective process of Deputy President and Article 149(1). It was argued that the Public Appointments and Public Appointments in brackets Parliamentary Approval Act and the Standing Order 45(3) do not apply to this sui generis constitutional process, and that the Supreme Court entrusted a Society for Human Rights Alliance versus Matemo and 3 others held that where the Constitution provides a specific procedure, statute cannot add to or amend it. It was also their position that no public participation was required for the nomination under Article 149, subarticle 1, does not prescribe public participation, and that the nomination and approval is an executive-led elective process, not legislative business, under Article 118. That it will be incongruous to require more process for a mid-term vacancy than a general election, where the ticket is approved by popular vote without prior public hearings. For the aforementioned reasons, the National Assembly and the clerk urged the court to dismiss all relief sought in the, with the council submitting that no constitutional violations had been proved. The impeachment was procedurally regular and substantively justified. Damages are not automatic, as no breach had been established, and awarding damages would punish Parliament for performing its constitutional duty. That pension and retirement benefits are for honorable retirement, not for removal by impeachment, and that quashing the resolution and nullifying His Excellency Kindiki's appointment will create a leadership vacuum and constitutional chaos. Council thus urged this court to dismiss the constitutional petitions with cost to them, find that the impeachment of His Excellency Gachaguas was lawful, constitutional and procedurally proper, and that the nomination, approval, and appointment of His Excellency Kindiki as Deputy President was valid and constitutional, and that the court should decline to grant any of the relief sought by the petitioners. On the third and fourth respondent cases, the Speaker of the Senate and the Senate, who are the third and the fourth respondents respectively, challenged the consolidated petitions through the affidavit sworn by Jeremiah Nyegenye, who is the clerk of the Senate and secretary to the Parliamentary Service Commission. The affidavit was deposed on the 21st of October 2024. From the outset, it was their case that under Articles 93(1), 96, subarticle 4, and 145 and 150 of the Constitution, the Senate is mandated by with the role of considering the impeachment of a deputy president. They asserted that process is guided by the National Assembly's Standing Order 64 and 5, which dictates the procedure for introducing and supporting an impeachment motion. To that end, it deposed that on the 1st of October 2024, Honorable Mutuse introduced a motion in the National Assembly seeking the removal of His Excellency Gachaguas on the basis of 11 grounds, including gross violations of the Constitution, undermining, devolution, attacking independence of judges, committing economic crimes, and publicly subordinating the President. It was their position that the National Assembly conducted extensive public participation from 2nd to 5th of October 2024 and formally approved the motion on the 8th of October 2024. Following the approval, the Speaker of the National Assembly notified the Speaker of the Senate of the resolution in a letter received on the 9th of October 2024, which included the motion, electronic evidence, relevant Hansard reports, public participation, advertisement, and reports, and court orders. He asserted that the Senate Speaker convened a sitting on the 9th of October 2024 through Gazette Notice number 13170, during which a motion to establish a special committee to investigate the matter was defeated. As such, the proceedings had to be held in plenary, and it was deposed that the Speaker designated 16th and 17th of October 2024 for the plenary hearings formalized in Gazette Notice number 13178. Speaking to the fairness in the process, the clerk deposed that on the 9th of October 2024, the Senate served an invitation to His Excellency Gachaguas and the National Assembly to appear to submit witness details and evidence. It was the case that on the 14th of October 2024, His Excellency Gachaguas indicated his presentation by Mrs. Swanya and company advocates and filed his response to the allegations alongside supporting evidence. They stated that the plenary hearings commenced on the 16th and 17th October 2024, and after the National Assembly concluded its case on the 17th of October 2024 at 1:15 p.m. His Excellency Gachaguas, lead counsel Mr. Paul Muite, senior counsel, informed the Senate at 2:30 p.m. that his client was missing and had been taken ill. It was pointed out that after suspending the proceedings until 5 p.m., counsel requested an adjournment to 22nd October. He stated that a substantive, subsequent procedural motion to sit on Saturday, 19 October 2024, to meet the constitutional deadlines was defeated, prompting His Excellency Gachaguas' counsel to exit the proceedings. They maintained that the Senate, across the judicial body, exercised discretion in granting adjournments, and His Excellency Gachaguas' counsel failed to provide cogent material evidence of his illness. As regards the constitutional timelines, it was their case that impeachment could not be posed without violating the Constitution. They refuted the claim that the trial occurred in absentia since His Excellency Gachaguas had actively participated through his advocate's opening statements, cross-examination, and the National Assembly's witness and filing of the respective witness affidavits. In challenging the claim that the public participation was not conducted, the Senate and the Speaker stated that an order of the High Court in Kerugoya did not mandate the Senate to conduct public participation, as the Senate functions exclusively as a trial chamber akin to a court. In conclusion, it was disposed that the Senate voted on the impeachment charges, where 5 charges comprising ground 1 on gross violation of the Constitution, ground 4 on undermining the independence of judges, ground 5 fidelity to the oath of office, ground 6 on crimes under national cohesion, and ground 9 on gross misconduct and ground 9 on gross misconduct concerning NAS were substantiated by the required majority. The clerk deposed that the Senate resolved to impeach His Excellency Gachaguas, a decision officially gazetted on 17th of October through Gazette Notice number 13400. On the foregoing, this court was urged to find that the impeachment power is inherently political and vests solely in Parliament, which triggered the political question doctrine, thereby inviting this court to exercise judicial restraint. Ultimately, the Speaker of the Senate and the Senate prayed that the petitions be dismissed with cause. The third and fourth respondents filed submissions dated for the 24th of April 2026, and they were highlighted by their legal team led by Professor Tom of Gender Senior Counsel, Mr. Edwin Mukele, Ms. Mercy Thanji, Ms. Opola, and Honorable Hilary Sigei. They maintained that the entire impeachment process meticulously complied with all constitutional timelines, including standing orders and the principles of natural justice. On the question whether His Excellency Gachaguas was accorded a fair and reasonable opportunity to be heard, they submitted that the hearing aligned with the due process and the Audi Alteram Partem rule. To define the threshold of a fair trial, they relied on the Black's Law Dictionary 7th edition at page number 725, and the Halsbury's Laws of England 5th edition 2010, volume 61 at paragraph 639. The dictionary defines the right to be heard as follows, and they quote: the rule that no person is to be condemned unless that person has been given prior notice of the allegations against him and a fair opportunity to be heard is a fundamental principle of justice. This rule has been refined and adapted to govern the proceedings of bodies other than judicial tribunals, and a duty to act in conformity with the rule has been imposed by the common law on administrative bodies not required by statute or contract to conduct themselves in a manner analogous to a court. End of quote. To bolster their case, the Senate and the Speaker referred to the President in Evans, Kidero and 4 others, was Ted Ndungu, Waititu and 4 others, 2014 Supreme Court decision, which approved the Supreme Court of India's decisions in Indru Ramchand, confirming that a fair hearing possesses 2 elements, namely the opportunity must be given and it must be reasonable. Council drew further support from the Uganda Supreme Court in Obiga versus Electoral Commission and another, and in Saulo Kandie versus James Kwambai Cheruyot, which is a Court of Appeal decision, to illustrate the right that the right to be heard is fulfilled when a party is supplied with the opposing evidence and given a full venue to present their case, comment, or call witnesses. As regards the sufficiency of written evidence and constructive waiver, they stated that His Excellency Gachaguas fully participated in the initial phases of the trial by filing comprehensive responses, witness statements, and documentary or video exhibits, which legally constituted his defense in chief under Rule 6 of the second schedule to the Senate standing orders. They submitted that an oral hearing is not an absolute and 3 others was a Speaker of National Assembly. This is a South African case, and the Kenya Revenue Authority and Menginya versus Menginya Salim Magara's case. They also relate to Swalwarjan versus Race Relations Board Limited. This is a foreign case, as well as R versus Immigration Appeal Tribunal. They also referred to the case of Jacob Ochanda versus Kenya Hospital Association Limited to demonstrate that a hearing can be fairly conducted through written representations. The Speaker and the Senate faulted His Excellency Gachaguas, stating that because he chose to walk out of the proceedings after the Senate had voted down an adjournment, it was deliberate boycott. They implored the court to find that voluntary absence constituted a constructive waiver of the right to be heard orally. Support to that end was drawn from various authorities, among them Regina versus Jones, R versus Governor of Brixton Prison, and the Ghanaian Supreme Court case in the Republic versus High Court of Accra. They affirmed that the Senate acted within its lawful discretion when it denied His Excellency Gachaguas' request to adjourn the proceedings due to his sudden hospitalization. In reference to the decision of the Supreme Court in Sonko and the Mate, the Senate and the Speaker emphasized that courts must be slow to interfere with the internal affairs and the procedural discretion of Parliament. Further support was drawn from the decision of the Supreme Court in the famous cycle agencies case and 4 others versus Mansukulal, Ramji Kuria, where it was observed that an adjournment requires sufficient cause based on proper materials. They argued that without formal medical proof of total incapacitation, the Senate was not required to stop its proceedings. To further credence to the foregoing position, they found support from the decision in Serem versus Republic, Court of Appeal decision, and Okaka and another versus Odundo, High Court decision, and it was their case that the strict approach was dictated by the mandatory 14-day timeline to dispose of special motions under Senate Standing Order number 74-2A. On the question whether investigation of charges met the requisite standard of proof, the Senate asserted that it thoroughly investigated and voted on each individual charge according to the established intermediate standard of proof, which is above a balance of probability but below reasonable doubt threshold. It was their case that the standard was set by the Supreme Court in the Sonko case, which declared that proving even a single charge is legally sufficient to sustain an impeachment. Consequently, they submitted that the court must decline to reevaluate the evidence or substitute its own finding for the political question decided by the Senate under Article 96, Sub-Article 4 and Article 145, Sub-Article 3 of the Constitution. On the question challenging His Excellency Gachaguas' claim that the Senate acted unprocedurally by failing to form an 11-member special committee under Article 143, Sub-Article 3b, the Speaker and the Senate submitted that the word may in the Constitution and Rule 2 of Part 1 of the second schedule to the Senate standing orders grant the Senate absolute discretion to choose between a committee or full plenary. They submitted that such interpretation is anchored in the Supreme Court case in the matter of the Speaker of Senate rendering or referencing the matter of interim independent electoral commission and the Court of Appeal decision of Cooperative Bank of Kenya Limited and versus Banking Insurance Finance Union, which is a Court of Appeal decision. They contrasted Article 135, Sub-Article 3b with Article 152, Sub-Article 7 of the Constitution, which uses the mandatory phrase, shall appoint, when dealing with the dismissal of Cabinet Secretary. It was their case that since a motion to form a special committee was moved but failed to be seconded under Standing Order 70, the Senate properly proceeded in plenary, meticulously satisfying the oversight parameters affirmed in the by the Supreme Court decision in the Sonko case. As regards the contentious issue of public participation, they contended that there was no legal basis for the Senate to conduct a secondary round of public participation because the National Assembly had already completed a rigorous national public participation drive between the 2nd and the 5th of October 2024 through extensive media notices and public feedback templates. They submitted that to demand a repetitive exercise from the Senate would be an imprudent waste of state resources. Separately, the Speaker and the Senate submitted that during an impeachment trial under Article 145(3)(a, the Senate acts exclusively as a quasi-judicial body evaluating specific charges rather than performing a standard legislative function, exempting it from public participation requirements of Articles 10 and 118. They dismissed the argument that Parliament was illegally constituted due to a threshold failure to implement the two-thirds gender rule. They further submitted that although the former Chief Justice David Maraga issued a dissolution advisory to the 4th President, the 12th Parliament dissolved by operation of law and the 13th Parliament was lawfully established following the general elections of the 9th August 2022. Seeking to rely on Article 261, Sub-Article 5 running to 7, the Senate and the Speaker submitted that the ground that the gender rule mechanism is intended to compel future compliance and not to retroactively invalidate state operations. They warned that declaring Parliament unlawful would cause an absurd constitutional crisis, invalidating national budgets, legislation, and public appointments, which violates the governance promotion mandate of Article 259 of the Constitution. They urge the court to practice judicial restraint as the gender dispute is actively pending before a 5-judge bench in Conchela and others as the Chief Justice and President of the Supreme Court in Kenya and others. The Speaker and the Senate rejected the allegation that the Senate was mandated to conduct an oral hearing for filling the subsequent vacancy of the office of the Deputy President. They pointed out that Article 149, Sub-Article 1 of the Constitution expressly grants the exclusive mandate to vote on and approve a nominated Deputy President to the National Assembly, entirely omitting the Senate. It was their case that by applying the statutory construction principle established in the case of Federation of Women Lawyers Kenya, FIDA versus AG, the Initiative of Strategic Litigation in Africa, statutes could be interpreted to override the explicit statute could not be interpreted to override the explicit text of the Constitution. On the strength of the foregoing submissions, the Speaker and the Senate urged the court to dismiss all the consolidated petitions with costs.
I will take over from the fifth respondent's case. The Attorney General, that is the fifth respondent, challenged the petitions through grounds of opposition dated the 7th of November 2024. She argued that the court should not elevate Parliament's factual assessments since its role is strictly to ensure that reasonable inferences were drawn from the available evidence. It was her case that the removal proceedings against H.E. Gachaguas were purely legislative, neither entirely administrative nor judicial, and therefore were not subject to standard administrative or judicial review as suggested under Article 47(3)(a) of the Constitution. Further, the Attorney General asserted that the court could not substitute the legislature's discretionary decision with its own, as doing so would constitute a usurpation of the constitutional functions of an independent branch of government. She maintained that the proceedings before the legislature were lawful, efficient, expeditious, and procedurally fair, since the adopted procedure successfully balanced the need to protect H.E. Gachaguas' constitutional rights, safeguard the process from abuse, and prevented unnecessary disruptions to public administration. Regarding public participation, the AG clarified that the Constitution did not permit members of the public to vote on an impeachment motion, as that discretion was expressly reserved for legislators who constitutionally represent the sovereign will of the people. It was explained that the National Assembly's role in the impeachment process was strictly preliminary and did not bind the Senate, which acted as a distinct state organ responsible for substantive proceedings and the ultimate decision. It described the consolidated petitions as disguised appeals regarding the merits of Parliament's decision and argued that the judiciary lacked an appellate mandate over the impeachment of a deputy president, since it is ill-equipped and constitutionally not designed to review or reevaluate the socio-economic and political utilitarian calculations made by elected officials. Finally, the Attorney General defended the subsequent nomination and voting into office of His Excellency Kindiki, and it was her case that the replacement process under Article 149(1) of the Constitution was sui generis, qualifying neither as an election nor an appointment, which meant that the provisions of Article 137 did not apply. The Attorney General concluded that there were no procedural infractions that affected the outcome, that the transition process was conducted within constitutional timelines by the proper constitutional repositories, and that the consolidated petitions lacked merit. The fifth respondent's submissions are dated 4th March 2026. They were orally highlighted by a team of counsel led by Professor Githu Muigai, Senior Counsel, alongside the Solicitor General, Mr. Shadrach Mose, Mr. Emmanuel Bita, now a judge of the High Court, and Mr. Charles Mutinda. The Attorney General submitted that accountable governance was a core part of the Constitution, which established removal from office through impeachment as one of the tools of governance amongst the many avenues of exercising oversight and facilitating accountability. He relied on the Supreme Court decision in Sonko, where the Apex Court stated that its purpose was to ensure integrity in leadership and prevent abuse of public office. It was was the Attorney General's submission that the removal of proceedings for a deputy president was textually committed by the Constitution to the National Assembly and Senate, and that both institutions were vested with exclusive power to remove the deputy president, subject only to procedural requirements set out in the Constitution and in the standing orders, that both houses were free to determine the procedures for receiving and considering the evidence necessary to discharge their duty to conduct impeachment hearing. With regard to the constitutional basis for impeachment, the Attorney General cited Articles 150, 144, and 145 of the Constitution, which she submitted established a sequential two-stage process. In the first stage, a member of the National Assembly initiated the process by filing a notice of motions supported by at least a third of all the members, which motion, if passed by at least two-thirds of all the members, was then transmitted to the Senate for substantive hearing. On the substance of the charges, the Attorney General submitted that the charges against H.E. Gachaguas were substantiated to the prescribed standard to warrant his impeachment. She identified the specific charges upon which H.E. Gachaguas was found culpable. On the standard of proof applicable to impeachment proceedings, the Attorney General relied on Sonko and the Court of Appeal decision in Wambora, both of which we have already referred to, which had held that the standard was above a balance of probability but below reasonable doubt, and that the allegations must be serious, substantial, and weighty, and must disclose with a degree of precision the constitutional provisions alleged to have been grossly violated. The Attorney General submitted that this court should not sit on appeal over Parliament's evaluation of facts and should not substantiate the discretion of the members of the legislature with its own. The Attorney General further relied on the advisory opinions of the Supreme Court in the Speaker of Senate and another, as well as the matter of the IEBC 2011 Supreme Court decision for the proposition that governmental powers were distributed among different organs, each exercising distinct functions under the Constitution, and that courts were required to respect the institutional mandate of a Parliament. The doctrine of presumption of regularity was equally invoked, encapsulated the doctrine of presumption of regularity, and it was submitted that government action enjoyed a presumption of legality and that the burden lay on the challengers to demonstrate unlawfulness. The Attorney General relied on the Supreme Court's decision in Odinga and another versus IEBC, our court and another, as well as it's the same decision, Odinga and another versus the IEBC, including our court and another, the Attorney General and another as interested parties and amicus. On a comparative jurisprudence, the Attorney General submitted that both the United States and the Philippines recognize the political nature of impeachment proceedings, and the power is vested in the legislature, thereby warranting judicial deference to the merits of legislative decisions. The Attorney General relied on the case of Nixon versus the United States, where the United States Supreme Court held that challenges to Senate impeachment procedures were non-justiciable under the political question doctrine, as well as the Duterte decision that we have already cited. On the part of the petitions relating to the nomination and approval of H.E. Kindiki, the Attorney General submitted that the provisions of Article 149 envisaged a sui generis procedure for the nomination and assumption into office of a deputy president. It was the Attorney General's submission that the process under Article 149(1) was neither an election in the traditional sense nor an appointment, as the text of the Constitution employed neither of those terms. In support of the sui generis nature of the process, the Attorney General drew on comparative constitutional provisions from the USA, Ghana, and Nigeria, each of which provided for a distinct mechanism of filling a vacancy in the office of Vice President through presidential nomination and legislative confirmation. The Attorney General submitted that as H.E. Kindiki was nominated by the President within 14 days after the vacancy arose, and the National Assembly voted on the nomination within 60 days, there had been no infringement of either the text or the spirit of the Constitution. Moving to the ninth respondent's case, the Honorable Mutuse responded to the consolidated petitions through a replying affidavit sworn on 22nd October 2024. He deposed that on 1st October 2024, pursuant to Article 150B, read with 145 of the Constitution and the Standing Order 64 and 65, he gave a notice of a special motion for the removal from office by impeachment of H.E. Gachaguas. He was aware that the special motion was a time-bound exercise pursuant to the Standing Order 64-2 and 65, which required that it be disposed of within 7 days of the notice being given, failure to which it would be deemed as withdrawn. Honorable Mutuse averred that while Articles 145 and 150 of the Constitution and Standing Orders did not expressly require public participation in a special motion, Article 118(1)(b) of the Constitution imposed on the Speaker of Parliament the obligation to facilitate public participation in legislative and other business of Parliament and its committees. He deposed that it was in that spirit that the National Assembly, with a view to facilitate public participation, invited members of the public to submit their views, and public hearings were thereby conducted across all the 290 constituencies on 4th October 2024. A notice dated 4th October 2024 by the Clerk of the National Assembly extended the period of public participation to 5th October 2024. Honorable Mutuse confirmed that on 8th October 2024, on the 3rd of October 2024, the High Court sitting in Kerugoya issued orders directing the National Assembly to organize, facilitate, and conduct further public participation at the constituency level, and that the National Assembly complied with those orders by extending the exercise to the 5th of October 2024. Honorable Mutuse stated that following the table